Good morning, Mr. Selega. Good morning, everybody.
Morning, Chairperson.
Yes, I got your message that Mr. Singh's counsel indicated that they might be a few minutes late.
Yes.
But I see that it's 16 minutes past 10 and they are still not here.
They are still not here, Chairperson. I have phoned the advocate again, and she indicated to me that they're running 10 to 15 minutes late because they needed to commission an affidavit of Mr. Singh. So it's a further affidavit, apparently, which they would like to hand up this morning. And that will take us to beyond 10:30 by the look of things.
Any affidavit they have for this morning obviously won't be used this morning.
Correct.
And it could have been dealt with later. So it's really, it wasn't a few minutes.
No, it's more than a few minutes.
Yeah. So the further 15 minutes or so was from what time? When you called them and they
From
said
just
that? 2 minutes ago.
Just 2 minutes before the
So that
the
will take us
chairperson
beyond
started.
1:30.
But she says she's apologizing profusely.
Yeah, that is quite late. I'm going to adjourn. It's just a pity that we are losing a whole 8 minutes. I'll adjourn again and come back at 1:30.
Thank you, Chair.
We adjourn. see that Mr. Singh and his counsel are still not here.
They are not, Chair, but the attorney is here.
Yeah, this is unacceptable. This is completely unacceptable. The commission doesn't have time. We're working into the evenings, we're working weekends to try and make sure we can finish time. We can't afford to lose time like this. I'm going to adjourn. I hope that whatever affidavit they prepared, going to adjourn until 11:30. I would like you to get a chance to read whatever affidavit they've prepared, so that if possible, that can be used today as well, because we are losing time.
Yes.
I'm going to adjourn and we'll return at 11:30.
Thank you.
We adjourn. the counsel for Mr. Singh and Mr. Singh are here now.
Yes.
Yes, I'm sure counsel for Mr. Singh would like to say something.
Yes, good morning, Chairperson.
Good morning.
First of all, we want to apologise for being late this morning. Unfortunately, as it goes with these things, we had a few challenges, some of them personal, others just running late. So we apologise for not being here on time.
No, that's fine. You have given me a full explanation in chambers.
Thank you.
That's fine. Okay, all right. Let's start then. And let's try and increase the pace.
Yes, Chair.
Yes.
Indeed.
Okay, all right. Please administer the oath of affirmation to Mr. Singh again.
Please state your full names for the record.
Anuj Singh.
Do you have any objection to taking the prescribed oath?
I do not.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Chairperson, before Mr. Seleka starts,
Yes.
based on the questions that was asked on the last occasion, we prepared an affidavit for Mr. Singh. We believe that it's in the interest of this commission that Mr. Singh start with some of those issues. I think having regard to where we were on the last occasion, it would give you and the commission clarity on some important issues. So we beg leave for Mr. Singh to first deal with the issues that's in the affidavit before Mr. Pule continues leading his evidence.
Mr. Seleka will see whether it accords with his plan to do so. But of course, if there were things that needed clarification last time, at some stage or another, the clarification should be given.
Yes.
Have you had a chance to look at the affidavit?
Yes, during the adjournment, I did glance through the affidavit. The affidavit itself is fairly short, it's 8 pages long, but the annexures are quite voluminous.
You haven't had a chance to look at the annexures,
Not all of
or
them.
some of them.
I looked at 1 or 2 of them.
Yeah.
But I've seen the contents of the affidavit. What I could do for Mr. Singh is I could ask you some of the questions which I intended asking Mr. Singh this morning, bear on the issues that he seeks to address in the affidavit. So I could follow my line, and then in the course of him answering, he could refer the chairperson to that affidavit, to the extent that he wants to answer some of the questions.
Well,
And I know the chairperson hasn't seen the affidavit.
yeah,
Yes.
you sent me just the affidavit on WhatsApp, and I had a superficial look. So I think that the important thing is whether it's going to be fruitful to ask him questions on these matters before you have read the annexures. If it will be manageable, that's fine. But I haven't read I've seen some parts of the affidavit. I haven't read it.
Yeah.
So of course you could continue on the way you had planned. And if Mr. Singh, in responding to those questions, uses information that's in the affidavit, that's fine. And but later on, when you have had a chance to look at the annexures and everything,
Yes.
and when I have had that chance, we might revisit the issues.
Yes, I think so.
Yeah. So I think let's carry on that basis.
Yes. Mr. Singh, you understand. So we carry on the basis that I have prepared, insofar as you need to refer to this new affidavit. Yeah,
I think when he answers, he can answer using the information that's in the affidavit.
Yes.
But since we haven't had
Yes.
read it, there might be difficulties if he's going to refer in detail to annexures. So maybe he can use the knowledge that he has and say that some of the things are dealt with in certain annexures at a later stage when we have all had a chance to read the affidavit and
Yes.
annexures. We can go back and then he can supplement his answers by referring in detail if he wishes to
Yes.
the annexures.
yes, Chair. Thank
Okay.
you. Okay, you follow that, Mr. Singh. Chairperson, the affidavits of Mr. Singh are found, well, the ones which are already in the bundle are found in ESCOM Bundle 16.
I've
that-
got bundle 16.
ESCOM Bundle 16. But the bundle, Chair, which I wish us to focus on as we proceed now is ESCOM Bundle 14 bracket C. ESCOM Bundle 14 bracket C, and from time to time I will refer to the relevant passages.
I don't want to forget this, Mr. Seleka.
Yes.
It relates to ESCOM, but not to Mr. Singh. I wanted to look for something in Mr. Marukane's affidavit over the weekend. I could only see the supplementary affidavit or second, not the first. Apparently, when my registrar mentioned the name to you, you
Oh, yes.
could not remember.
Yes.
But maybe I didn't pronounce it correctly when I spoke to her, but I thought I had, because I subsequently checked the spelling, and I thought I got it right.
Oh, okay.
You know which affidavit I'm talking about?
Yes, if it is then Marukane Chair, no.
Yes, well,
Yes.
I don't know his first name, I just know the surname.
Yes.
So if you can indicate to her where she will find that.
Yes.
Yeah. Okay, right.
Thank you. Mr. Singh, just by way of recapping on this, we were mainly dealing with the McKinsey matters last time when we adjourned. We dealt with the corporate plan and we started with the MSA. And on the corporate plan, it was a debate, in inverted commas, about who rendered services. And we were trying to inquire as to who rendered services. And in regard to we had gone beyond that inquiry about who rendered services. And on the MSA, we were dealing with the conclusion thereof. Now, I just want to quickly finish off by reference to the affidavits of Dr. Weiss and Dr. Amankwa on the services or the identity of the entities which rendered services in respect of the corporate plan. And I'm going to simply refer you to the paragraphs without too much time being taken on that. So that's ESCOM Bundle 14, Chairperson. Mr. Singh, I will start firstly with the affidavit of Dr. Weiss. And I will read from paragraph 38. Oh,
Sorry,
page 692. 692, yes.
Black numbers, correct?
The black numbers as usual.
Six.
692. You are the,
Paragraph 38.
yeah. So you will see the heading there above paragraph 37. It says introduction of regiments / Trillion at ESCOM and subsequent dealings with regiments Trillion. And then the subheading is introduction of regiments at ESCOM. Then paragraph 38 says, as discussed above, when Mr. Molefe and Mr. Singh transitioned from Transnet to ESCOM in mid-2015, regiments worked with McKinsey on a 2-month project that arose out of the CEO and CFO onboarding. I understand that Regiments was an established firm and had relevant expertise on the financial and balance sheet aspects of the project, and thus well equipped to lead the portion of the project. I was aware of the project, but had limited personal involvement in it, and thus limited interaction with Regiments at that time. Then under paragraph 39, you have a heading where he says mid-2015 work with regiments at ESCOM. And then paragraph 40 reads, McKinsey presented the model developed during the 2-month project to Mr. Singh around August 2015, and was asked to support ESCOM in writing its annual corporate plan based on the model. Though McKinsey had not previously been engaged to provide support to ESCOM in writing this annual submission, I believe the model was representative of the extensive institutional knowledge we had of ESCOM, and that Mr. Singh recognized the importance of such existing knowledge during a period of great challenges for ESCOM when a sound corporate plan was urgently needed. Then he says in paragraph 41, we wrote a proposal, and the letter of acceptance we received from ESCOM specified McKinsey was required to engage an SD&L partner. Given Regiment's financial modeling capabilities and work on the previous projects, which formed the basis of the corporate plan, we envisaged Regiments as the SD&L partner for the corporate plan project. In paragraph 42, he then says, as explained further below, in October or November 2015, we learned that a regiment partner with whom we had worked on the 2-month project was planning to a spin-off of the management consulting arm of Regiments, which would ultimately result in the creation of an entity called Trillion Management Consulting. We did not have a formal subcontracting agreement for the corporate plan, but we worked alongside Regiments / Trillion, who provided financial component of the modeling required for the corporate plan. You see that, Mr. Singh?
Yes, sir.
Now, the dates of October and November 2015 are significant in regard to a partner of Regiments going to form a company called Trillion Management Consulting, because he comes back to that in paragraph 45. And you will see that, as he says, as discussed above, around October or November 2015, we learned that a Regiment's partner, Dr. Eric Wood, was in the process of buying out the management consulting arm of Regiments from his business partners, and would spin it off into Trillion. At that time, Regiments was already working on the corporate plan, and McKinsey was finalizing the turnaround program with Eskom, which envisaged Regiments as McKinsey's SD&L partner. Though my personal interaction with Regiments were limited at the time, I understood that many consultants then at Regiments would move over to Trillion with Dr. Wood and conduct the same management consulting business under the Trillion corporate name. And what I wish to draw to your attention, and I think I must have done so previously, is that sentence which he says, at that time, Regiments was already working on the corporate plan, and McKinsey was finalizing the turnaround program. I am going to read again, or further, from the affidavit of Mr. Amankwa. And I want to read a paragraph where he makes concluding remarks after several paragraphs in his affidavit. So let's go to page, and I'll give you a chance to comment after that because the theme is the same. Page 702.
Sorry, just repeat that.
702.221.
7.221.
Yes. Now, just for context,
Remember to just tell us, Mr. Solega, whose affidavit you
yes,
are referring to at 702.21.
yes, the affidavit that we read, that we have just come from now,
Dr. Weiss,
is Dr. Vass's affidavit.
or this one is still his?
This one now is one of Mr. Amankwa, chairperson.
Okay.
Safradu Yeboah Amankwa.
Okay.
It starts on page 702.174.
Okay, you can continue.
We read certain excerpts from this affidavit previously. And I have said page 702.221. Just by way of context, Mr. Singh, what Mr. Amankwa deals with start on the page 702.220. And it's under the heading 9 February 2016 letter. And his chairperson on page 702.220.
Not actually, but I did hear that. I'm checking something else, but
Okay.
you can continue. I've got 220.
Yes. Mr. Singh, let's start on point 220, paragraph 20.18.
So we're going to 220.
Yeah.
Okay.
Paragraph 20.18. So he says, by way of summary, and in light of what has been stated above, I draw attention to the following features of the relationship between McKinsey and Trillion. One, he says, McKinsey entered into discussions with Trillion in order to explore the possibility of working with Trillion as a supplier development partner at Eskom. Those discussions were terminated in March 2016 when Trillion failed to satisfy McKinsey's due diligence requirements. Sub 2, McKinsey never entered into a subcontract or any other contractual relationship with Trillion, whether for the corporate plan project or the turnaround program. Trillion has never been a subcontractor to McKinsey. And then he mentions other points. Then you
Well,
go to-
they are important. Number 3 says McKinsey never paid money to Trillion.
Yes.
And says 4, McKinsey never authorized payment to Trillion by ESCOM. 5, any payments that were made by ESCOM to Trillion occurred after McKinsey had informed ESCOM of the fact that Trillion had failed its due diligence requirements. 6, McKinsey has found no evidence to suggest that any of its personnel were involved in corrupt activities with employees of Trillion. I just thought 3, 4, and 5
Yes,
appear to be quite important in the light of the issues.
Yes, no, the chairperson is correct. Those aspects are important. And then Mr. Singh, in regard to this letter of the 9th of February 2016, which relates to the direct payment to Trillion of 30.6 million, let's read on the next page. It says, paragraph 21.1, on 9 February 2016, Mr. Vikas Sagar transmitted a letter to Mr. Prish Govender of ESCOM, and he references the annexure, MCK 65. The letter related to the professional services contract, that is the corporate plan. The letter recorded that McKinsey has subcontracted a portion of the services to be performed under the agreement to Trillion Proprietary Limited. It authorized ESCOM to make payments directly to Trillion, but only if McKinsey confirmed in writing that it was satisfied with the relevant services performed by Trillion and that the amount of the invoice was correct. 2 conditions that were never met. Then the next paragraph, 21.2, says Trillion was never McKinsey's subcontractor under the corporate plan, because the assertion in the letter that McKinsey had subcontracted to Trillion was wrong. This letter has engendered significant confusion. While it was expected at the time that Trillion would be McKinsey's supply development partner on the turnaround program, which Mr. Singh aired, which would have been administered under the MSA, as explained elsewhere in my statement, McKinsey had not yet entered into a subcontract with Trillion and would indeed, in the weeks following the letter, decide not to do so. And please turn to page 702.
Well, Mr. Selega, be careful not to have a situation where you have read to Mr. Singh a number of things,
Yes,
and
Chair.
when you ask him to comment, he can't remember a lot of things. So I think you need to
Yes,
break it into manageable portions.
components, yeah. That's all right, Chair. It's just that the paragraphs I wanted to read all deal with the same theme.
Yeah, okay, all right.
They
Okay,
all
that's
deal with
fine.
the same theme.
Okay, all right.
I will give him a chance just to respond to these ones before I go to the next ones. Mr. Singh, lastly, turn to page 702, 2.224. 224. Yes. 224, paragraph 21.7. He says, in sum, McKinsey regrets that the 9 February letter contained inaccuracies, which generated confusion and misunderstanding. All of the people who had involvement in the creation of the letter have been disciplined or have left the firm. But the notion that the 9 February letter can be taken to confirm that Trillian was actually McKinsey's subcontractor is wrong. This has been thoroughly investigated and cannot be reconciled with contemporaneous information. Such evidence makes clear that Trillian was not McKinsey's subcontractor, was still undergoing the due diligence process, and never became McKinsey's subcontractor. I can read further, but I suppose you get the point of what the two gentlemen are making in regard to the corporate plan. So what emerges from here is that in respect of the corporate plan, McKinsey was not, Trillian was not just not, but never McKinsey's subcontractor in respect of the corporate plan. We can deal with that first. Or you can even address it in respect of the MSA, which is the turnaround program, in respect of which they also, or he also says, Trillian was never the subcontractor to McKinsey because of failing to pass the test on the due diligence. But let's first deal with the corporate plan.
And as you prepare to do that, Mr. Singh, I just want you to be aware that last time, and I think the occasion before last time, we dealt with the issue of whether it was regiments who had a subcontract with McKinsey or Trillian or both, and the question of who rendered the services, was it Trillian or regiments, and the question of whether ESCOM should have paid Trillian directly. So I don't want us to repeat the same thing, but I do believe that Mr. Seleka was right to draw your attention to the portions of affidavits that he has done so. So as you respond, just bear in mind that I know what you have, what your version was that you have said before. Mm-hmm. If you don't intend changing it and you just want to add or clarify, it's enough. You don't need to go into details about it today.
Thank you, Mr. Chair. And again, just from my side, just an apology for the delay that we had caused this morning.
Yes.
But at least I'm of the view that the information that was provided this morning would eventually,
yes,
in time,
yes,
reduce the amount of time we'd have to spend on this.
No, that's fine. Your counsel did explain to me in chambers. It's just that the way it happened wasn't good. But as I have said, your counsel has explained everything to me. And
thank you for your indulgence and understanding, sir. Mr. Chair, just a couple of points before we go into the responses. Firstly, in terms of Dr. Weiss's affidavit, Mr. Chair, I would like to place on record that the paragraphs that I'm asked to respond to did not form part of the 3-3 notice that we received.
not form
Part of the 3-3 notices that we
is that
received
so?
relating to Mr. Weiss's statement, because we received a redacted version of that statement.
Is that so?
Right?
But have you had a chance to read them subsequent to the 3-3 notice that did not include them, or you have not had a chance to read them?
Well, we haven't received the unredacted version, I think, as of now. But obviously, we've read it now through Mr. Seleka's passage.
Oh, so your only chance to look at them was now?
Was now. We did have, or I certainly had occasion to read Dr. Weiss's transcripts, however, relating to his evidence. And secondly,
Chairperson,
Sorry.
to interrupt. Maybe just to place on record that we have in writing quite a long time ago requested the unredacted versions of both Dr. Weiss and Fine's affidavits. As I think in my client's response to what we were given, he makes it quite clear that he's only been given certain pages with certain paragraphs. And up to now, and I think I have approached my learned friend also on one of the occasions, but
Yes.
we've not yet received the unredacted
Yes.
versions.
Okay, no, Mr. Selega?
Thank you, Chair. Chair, I know that we traversed this last time. Mr. Singh was given the affidavit through the money flow work stream because the evidence of Dr. Weiss was led by the money flow. So the request, I think, would have been addressed to that work stream. But the full affidavit of Dr. Weiss has been in the bundle. Mr. Singh has been given the bundle from the time, or prior to the time of his appearance. And we have asked him questions previously on 2 occasions relevant to that.
I do remember that there was a reference to an affidavit of Dr. Weiss. It's just that I don't know whether he has provided one affidavit or more than one, but I do recall that there was reference to at least an affidavit of Dr. Weiss. If you say to me this is the only affidavit, then it means it was this one.
It is this one, but what Mr. Singh and my learned friend are saying is that when they were given the affidavit the first time around last year, it was redacted
By the money flows.
by the money flows.
Yeah,
It was redacted.
yes.
But I've since explained to them, Chair, and even here in an open session, that witnesses are given affidavits to the extent that they are implicated. Mr. Singh has dealt with the affidavit in reply. He has a replying supplementary affidavit where he's expressly saying the affidavit of Dr. Weiss doesn't implicate him. So all we are doing from our point of view is to put Dr. Weiss's affidavit in the bundle for his benefit, and then we put the version of Dr. Weiss's to him.
But your real answer to the concern
Yes.
is that Dr. Weiss' affidavit, to which you have referred now, has been in the bundle that was given to Mr. Singh quite some time back,
Prior to his appearance,
before his first appearance
before his appearance in the OSCOM matters.
in the ESCOM matters.
Yes.
Yes. Counsel for Mr. Singh, you accept that?
Except that, Chairperson, I think what
Yes.
my client tried to explain and what we're trying to explain is that at the time when he responded, it was a
Yes.
partial response to a redacted version.
Yes. Yes.
So basically, he can't be faulted for
Yeah.
only dealing with those specific paragraphs.
Yeah, okay, no, that's fine. As I understand it, Mr. Singh, the Dr. Weiss affidavit was included in the bundle that was given to you before you came to testify in the ESCOM work stream last time, for the first time. And if that is so, it would seem that there has been enough time for you to familiarize yourself with it. And from what Mr. Selega says, it does look like you did look at it and you didn't think there was anything implicating you. And you may be right about that, but what Mr. Selega is doing is saying, here is something that might not implicate you in Dr. Weiss' affidavit, but which might be contrary to your version about Trillium. So that I think that's the point.
Mr. Chair, the point is taken. I think my additional comment regarding this is, Mr. Chair, if the issue relating to Dr. Weiss was going to be relevant to the discussion,
Relating to?
the affidavit of Dr. Weiss was relevant and was produced in the bundle. Mr. Seleka is correct in saying that the affidavit that we've been provided for before did not implicate. Yet we commented on the paragraphs that required comment. If it was as significant as what we are now saying, my question is, notwithstanding the fact that it did not implicate, we should have been given the opportunity to have commented on it in its entirety.
Well, but I'm told you said it doesn't implicate you.
On the redacted version, Mr. Chair.
Yes.
Not
But
on
this one, as I understand it, which is not redacted, was part of the bundle that was given to you a long time ago.
Yes, Mr. Chair, but the comment around not being implicated relates to the
Okay,
unredacted
no,
version.
I understand that, yes.
And the similar point I have with Mr. Amankua,
Yes.
affidavit.
Yes.
Yes, it is now forming part of the bundle. We have access to it because
Yeah.
of Mr. Seleka
Yes.
has given it to us.
Yes.
But again, if we were placing such reliance on this document, as we are now doing, then I would have at least expected that this would have been provided to us for us to provide an appropriate affidavit.
Yes. Well, but I think the bottom line is, as far as these particular paragraphs that Mr. Seleka has referred you to, as I understand the position, they might not be implicating you. All he's doing is, you have given a certain version, and here is somebody else who might be talking, not having you in mind, but say something that might be contradicting what you want to say. In fairness, he wants to give you a chance to say, what do you say about Dr. Weiss, who says the following things?
You know, I agree, Mr. Chair. I just
Yeah.
wanted to place on record my reservations,
Yeah.
but I've done it.
Okay.
So
Okay.
in that light, we can continue.
No, that's fine, yeah.
Mr. Chair, I'm just trying to think the best way of dealing with this matter. Okay, it's fine. Let's deal with 692 first, relating to Dr. Weiss's comment.
You want us to go to what, page 220 or what
No,
page?
sorry, sir, 692.
692 first, yeah. Okay. Yes, you may continue.
Mr. Chair, if we look at the paragraphs that have been referred to by Advocate Seleka, as he had mentioned, they relatively have one theme that runs throughout it, is that Dr. Weiss was of the view that at some point in time, there was regiments that were doing certain amounts of work, and there was then a period of time when there was a, let's call it, merger or acquisition type of initiative that was happening between regiments and Trilling.
A spin-off.
A spin-off.
Or rather-
A spin-off merger.
Yeah,
Let's call it a buyout.
I think there would be a normal word for it. A breakaway.
Yes.
There was to be a breakaway from regiments.
Yes.
Yeah.
So, Mr. Chair, I think I certainly do not deny that, but what I want to raise in terms of the issue relating to whether Mr. Weiss has concretely concluded that Trillium or regiments had done the corporate plan work. If you have reference to his transcripts, which I've said I've read, and we can probably go to the relevant paragraph, when he was posed the question, okay, he did not definitively answer the question. He basically said there were emails, there was training, there were people, there were meetings, and regiments and Trillium people attended these meetings.
Regiments and Chilean people.
Attended these meetings,
Yeah.
were trained as such. Emails came from Trillium email addresses, they came from regiments' email addresses. So he could not conclusively conclude that Trillium had not done the work, from my recollection of his transcripts. And that is my response to the question relating to Dr. Weiss's comments.
But of course,
Mr. Chair, for now, if you allow me.
No, before you proceed,
Sure.
I just want to say, depending on whether you accept his evidence that Trillian never had a subcontract with McKinsey, your answer that you gave might not be so important.
Mr. Chair, I don't think the question whether Trillian had a subcontract with McKinsey was put to Dr. Weiss.
Yes, but he, in his affidavit, in the passages that Mr. Selega read earlier on, if I recall correctly, it's just that I was reading other passages that he might not have read as well, so I may be mistaken. But he does say somewhere that, no, actually in one of the passages that he read, where I even read more of the paragraphs, he does say that Trillian never had any contract with McKinsey.
Mr.
So
Chair.
I'm saying if you accept that, and I don't know if you do accept it, if you accept that, it may be that the fact that they may have certain people who were with regiments or Trillian attended meetings, the weight one attaches to that might be different if compared to a situation where there was a contract. So in other words, if the contract was only with regiments, whatever those personnel may have been doing, they may have been doing for regiments and not Trillian, if Trillian had no subcontract with McKinsey.
Mr. Chair, firstly, the passage that you're referring to comes from Mr. Amankua's affidavit.
Oh, okay, maybe,
Not
yeah.
Dr.
Yes, not
Weiss.
Dr. Weiss, maybe.
And
yeah.
I will deal with that when we're dealing with Dr.
Okay,
Amankua's
that's
affidavit.
fine, that's fine.
But for now, my response relating to the paragraphs is that, from what I recall from Dr. Weiss's transcripts, is that he is not definitive on the
It's
question.
not
whether-
definitive.
He was not definitive in terms of saying regiment's people did the work on the corporate plan. He was not. Okay? And I will come back to this point when I deal with the issue of Mr. Amankua's comments. In having to deal with Mr. Amankua's comments, I think, Mr. Chair, I would have to refer you back to one of my affidavits. I'm not too sure which one it is. It's the one that we respond to the corporate plan. It's the first.
You want your counsel to assist to remind you?
I know what it is.
Oh, okay.
Eskom Bundle 16, page 591.
590.
Are you referring to your affidavit starting at page 591 of Band 16, Mr. Singh?
Sorry, sir, I'm there. I'm just looking for the relevant
Okay,
paragraphs myself.
okay. Are you looking for a paragraph that says what, so we can assist you if we see it?
In terms of the SDLN, I think I found it in paragraph 18.
The
Paragraph
MSA.
1.5.
You see, Mr. Chair, if you look at paragraph, so page 597, we deal with the point that I was just making, which states, Dr. Weiss in addition outlines how Trillian came to be an SDL partner instead of regiments. In summary, he outlines the following in this regard. Dr. Wood intended to start up his own black account management consulting called Trillion. This would be achieved by buying out Regiment's management consulting division. McKinsey communicated with both Trillion and Regiment staff. McKinsey trained staff that moved from Regiments to Trillion. So, Mr. Chair, this is what I was talking about in terms of the fact that it was not actually definitive to say Regiments did not do the work on the corporate plan, firstly.
Sorry, Mr. Singh. But he's talking about Trillion becoming an SDL partner of McKinsey instead of Regiment. That is in regard to the turnaround program, the MSA. It's not the corporate plan.
Mr. Chair, we can check that, but my understanding and my recollection of the transcripts was that was in a response to a question as to whether he could say whether Regiments or Trillion was actually the people that did the work on the corporate plan. Further, Mr. Chair, I would like to take you to the emails that relate to the 9th of February letter. Find it.
In fact, Mr. Singh, you have answered that question yourself in the paragraph, in the preceding paragraph on the page before, which specifically shows that his answer relates to the turnaround program and not the corporate plan.
Sorry, Mr. Select.
Yes.
Just give me 1 second. I'm just looking for something.
Okay, no, that's fine.
Okay, Mr. Chair, I'm not sure where this is. Sorry,
You want to indicate what you are looking for?
I'm looking for the emails that relate to the 9th of February letter.
An email from who to who?
It's a string of emails, Mr. Chair,
Oh.
that culminated in the issuance of this 9th of
That relate to the letter from McKinsey that
Yes.
talked about Trillion.
Trillion.
Okay, Mr. Sleg, are you able to assist him? And his counsel can indicate if she's able to say where we find those
I think it's
emails.
in one of the affidavits. But while we're looking for that, Mr. Chair, in the interest of time, maybe I can just deal with.
Or what we can do, we can deal with other matters and then later
No, I
on.
will deal with Mr. Amankua's
Yes, okay.
responses to the
Okay.
while we try and find
Okay.
this. So we were looking at Mr. Amankua's issues relating to paragraph 2018.
Are you done with Dr. Weiss?
No, I'm saying
You will come back.
I'll come back once we
Okay,
find the
all
emails,
right. That's fine.
if we indeed have them.
Mr. Selega?
Yeah. Mr. Singh, before you move on to Mr. Amankwa,
Yes, sir.
I was saying to you in your affidavit, you referred the chairperson to page 597. and you read paragraph 18.
Yes.
And I was drawing to your attention that what Dr. Weiss is talking about there is the proposal to have Trillion as an SDL partner of McKinsey in the turnaround program and not the corporate plan, because we are dealing with the corporate plan.
That is correct, sir.
Yes. And I'm saying the answer that gives credence to what I'm putting to you is evident from your quotation in the previous page, that he's specifically dealing with the turnaround program. You quote him from page 595, paragraph 17.
That is correct, sir.
And in summary, Dr. Weiss states, and then you have all those paragraphs.
Yes, sir.
Regiments was actually quite capable internationally, and he talks about regiments. You turn the page, you go to the last paragraph on that page. He says, we have worked with them, that is regiments, before and even done the due diligence with them before. And this, you know, how, and we consider them also as potential supply development partner for ESCOM turnaround program. Then you go on to say what you say in paragraph 18. And you are correct insofar as it is the turnaround program, because they did intend to replace regiments with Trillion as a subcontractor in respect of the turnaround program.
Mr. Chair, as I said, I will check these transcripts and come back. If indeed it is that, then we will obviously accept that. But
No,
for now,
that's fine.
I am saying the reason why I put this in is because of my distinct recollection that this was asked
No, that's fine.
as it relates to page 29 of his transcripts.
You'll have a chance to look
Yes.
at those emails and then come back.
Then Mr. Amankwa.
So, Mr. Chair, in terms of responding to Mr. Amankwa's affidavit relating to paragraphs, on page 702.221, which is paragraph 20.18, 21.1, 21.2, and 21.7. Mr. Chair, in order for me to respond, I would need for the chairperson to actually go to paragraph 21.5.
We're back to 114, is that
Yes,
right?
yes, sir.
What page?
Let me just get it for you, sir. So we on, Mr. Chair, 702.221.
So just give us the reference again, Mr. Singh.
We're starting on 702.221, which is where you started. And you
Yeah.
quoted all of those paragraphs.
Oh, yes.
Right?
I've got it.
Thank you.
So, Mr. Chair, in order for me to respond to those specific paragraphs and the issue that was put to me by Mr. Seleka, I would need for the chairperson to go to paragraphs 21.5, which is on page 702.221.
Yes, I am there.
Okay.
Yeah.
Mr. Chair, if you would allow me, I would read the following. This 9 February 2016 letter had been prepared at the request of ESCOM
Yes,
and Trillion,
at the request of both.
at the request of both.
Yeah.
Okay?
And was the request in writing?
Well, Mr. Chair, that is
That's
from
what
the
will
emails.
be checked.
Yes.
Yeah. Okay.
and Trillian, in order to streamline the process for Trillian to receive payments for work it had undertaken to that date in conjunction with the corporate project plan.
You are reading now from page 702.221, what paragraph?
Paragraph 21.5.
Or at 222, yeah. Okay.
Oh, sorry, yes,
All right.
702.222.
Yeah,
Paragraph 21.5.
yeah.
It says, let me start again, Mr. Chair. This 9 February 2016 letter had been prepared at the request of ESCOM and Trillian in order to streamline the process for Trillian to receive payment for work it had undertaken up to that date in connection with the corporate plan project. Full stop. He then puts in brackets, this letter had nothing whatsoever to do with the turnaround program. This is clear from the content of the letter. Okay? So what it says to me, Mr. Chair, that this letter was not simply contemplated by somebody in McKinsey that made a mistake to issue this letter. Firstly. Secondly, he then goes off to state in paragraph 21.5, bracket 1.
Yeah.
Dr. Weiss, a McKinsey partner, and Mr. Sega consulted with McKinsey internal legal advisor regarding the form and content of the letter. As a result, certain internal communications are subject to attorney-client privilege and have not been reflected below. But what is important for me is that Dr. Weiss, whose affidavit we've just been through, is part of this process in preparing this letter.
And I'm not sure that Mr. Selega, an internal legal advisor, would give rise to an attorney-client privilege.
Well, that was the other point that counsel was going to raise, but
Yeah, I mean,
But
the
for now.
internal legal advisor is just an employee.
yes, exactly.
Yeah.
Right?
Yes. So they might have to produce those those communications that they didn't produce because they sought cover under attorney-client privilege.
And Mr. Chair, we would implore that we would actually get them, because we'd like to see what this was.
Yes.
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 We take
Well,
it
that
on.
must be pursued, Mr. Selega,
Yes,
if it
Chair.
hasn't been pursued, yeah.
Yes, Chair.
Yes, Mr. Singh.
Then on subparagraph 2, it says, on 26 January 2016.
I'm sorry. I'm just thinking about something with regard to my agency. No, but I think it's something to be dealt with outside of the hearing. Okay, all right, continue.
Mr. Chair, then 21.5, bracket 2. On 26 February 2016, Trillian, represented by Mr. Clive Angel and others copied, wrote to McKinsey, Dr. Weiss and Sega. So this is the emails that I'm trying to find, Mr. Chair, but obviously it's confirmed. Seeks assistance in receiving payment from ESCOM. And he actually attaches the same emails that I'm trying to find. Mr. Angel asked McKinsey to write to ESCOM on Trillian's behalf, seeking permission for McKinsey and Trillian to invoice ESCOM separately, under any contracts where Trillian is appointed supply development partner. Okay. And I concede it's any at this stage. On 8 February 2016, Sega emailed Dr. Weiss relating that ESCOM had asked McKinsey to issue a letter stating that Trillian can invoice ESCOM directly. And there's the email again. Mr. Vikas stated that he had received a request from Mr. Angel and asked Dr. Weiss whether he had also received the same request. In response, Dr. Weiss informed Sega that he had not received the request. But obviously that's contrary to the email. Bracket 4. On 9 February 2016, SEGA, after consulting with McKinsey in-house counsel, sent the first draft of the proposed letter to Mr. Angel and Dr. Wood at Trillian. And there's the attached emails. Later today, SEGA sent the signed letter to Angel and Dr. Wood relating that this would be the letter they would be sending to ESCOM. And then there's the letter. Then, bracket 5. Shortly thereafter, SEGA also transmitted the letter to Prish Governor at ESCOM. While the covering email discusses the MSA contract, the 9 February letter only relates to the fixed fee 6-month corporate plan for which work had largely been completed at the time of this letter. This is clear from the content of the letter. ESCOM also confirmed that the 9 February letter related solely to the corporate plan and provided no authority whatsoever in respect of the turnaround program. Para 6. In addition, the letter transmitted to ESCOM includes 2 important conditions that requires McKinsey to issue written confirmation that of our satisfaction of the relevant services performed by Trillian to McKinsey, and to confirm the correctness of the amounts invoiced. None of these conditions were fulfilled. Again, bracket 7. Later on 9 February, Angel reverts to Trillian, proposed changes to the letter. And there's an email attached. These request changes from Trillian, including removing the conditions prescribed above, as they would introduce further administrative issues into the process because the letter only referred to the corporate plan contract. McKinsey did not adopt Trillian's proposed amendments. The correspondence further advises the parties' understanding at the time of the letter submitted to ESCOM related exclusively to the corporate plan project.
Yeah, evinces.
Evinces.
Yeah.
Never heard the words. So bracket 8. Mr. Clive Angel followed up Mr. Vikas's email noting that Trillian had invoiced ESCOM. And under the conditions in the letter, McKinsey needs to write to ESCOM to the effect that McKinsey was satisfied with the work Trillian had done on the corporate plan. ESCOM never requested such a letter of satisfaction, and McKinsey never sent such confirmation. ESCOM has confirmed that the 9 February did not in itself, basically, I would like to stop there, Mr. Chair, in terms of the question that was posed by, or the issue that was raised by Mr. Seleka, is that, Mr. Chair, I do not believe that if you read these passages, that it can be simply dismissed that this letter was an erroneous letter that just happened to be issued. At
Say
all,
it seems to have been, before it was sent to ESCOM, you say it seems that it was subjected to quite some detailed scrutiny within McKinsey and Trillian.
Mr. Chair, in terms of the email trail that I'm requesting to be provided, you will even see post the letter, the legal head of McKinsey follows up on the letter to suggest, is there anything further that has actually happened relating to this letter? He then escalates it to the head of the accounts department within McKinsey to say, please follow up on this matter and make sure it is dealt with. She then sends an email to ESCOM, saying to ESCOM, and this went to a lady called Marianne Hendricks, who I think is the PA of Mr. Prish Governor, who was the project manager on this project, to state that should you have any issues relating to this matter further, please bring it to my attention within McKinsey, so I can elevate it to the appropriate leadership level within the company to ensure that these things are streamlined. Now, Mr. Chair, taking all of that into account, I do not understand how McKinsey basically says that this letter was prepared on the basis that it was incorrect and stand away from it. Mr. Chair, this brings me to another point that I'd like to make to the Commission, for the Commission to take note of. Mr. Chair, these documents, this letter, 9 February letter, is a letter that has been issued by McKinsey, signed by a partner of McKinsey, received by Eskom. Now, Mr. Chair, when Eskom receives this letter, in what mind does Eskom receive it? It receives it in good faith that McKinsey has issued this letter. What does Eskom do with it? Eskom places reliance on it, that this letter was received in good faith. Now, for whatever reason, McKinsey decides to sidestep this letter and say, no, we didn't issue it, or it was invalid, or for the fact that these two clauses in the agreement was not fulfilled by Eskom, therefore it's invalid. Park for 1 minute, Mr. Chair, the fact that the letter may have in Eskom been used for other purpose. But for now, the purpose that we're using the letter is to understand whether McKinsey at any point in time contemplated Trillian to be their SDLN partner. And from what I have read to you, Mr. Chair, I cannot find it in my being to suggest that they were not. So McKinsey can say and do whatever they want, but on objective fact that I've just read to you, in Mr. Amankwa's affidavit himself, would suggest that they at all material times believe that Trillian should have been paid for the work that they did on the corporate plan.
Yes.
Yeah, just talking about Eskom receiving it in good faith, Mr. Singh, just remember that he says this was a letter at the request, prepared at the request of Eskom and Trillian.
Yes, sir. That is my point. Mr. Chair, again, if we look at...
But let me just finish. So it's not as if the letter comes unexpected to Eskom, and Eskom simply, oh, it comes from McKinsey, we will act on the letter in good faith. It was specifically Eskom and Trillian who requested the letter to be prepared, according to Mr. Amankwa.
Mr. Chair, again, McKinsey is a world-renowned company. They are a global company. If they receive a request from Mr. Singh, and Mr. Singh says to them, listen, I want this letter. Or it comes from Mr. Molefe, or it comes from Mr. Governor, or it comes from whoever in Eskom. And it purports to request McKinsey to not factually represent the state of affairs that McKinsey knows. Why would McKinsey issue the letter? Or why would McKinsey have to issue the letter? And that is where I'm saying, if I request something in good faith, I expect the reciprocation in good faith. And therefore, we rely on letters, or we rely on assertions, or we rely on representation, or we rely on warrants that are made in good faith.
Well, speaking generally, there ought to be no problem with placing reliance on a letter that genuinely comes from McKinsey. But two things that I want to clarify. One, as I recall that letter, it did not specify certain conditions, which, as I recall from last time we were dealing with that letter, would have had to have been met before any payment could have been made to Trillian, and where they met.
Mr. Chair.
Chairperson, I think the letter that we're speaking about is AS 19
Yes.
to my client's affidavit.
Yes.
So I'm going to leave it there because I've got a further issue with the interpretation that's attached to the letter. But I'm going to let my client deal with it.
Yes.
And if necessary, I will bring it to your attention.
Yes,
Thank
no,
you
no,
very
that's
much.
fine. Which bundle, what page is the letter, if you are able to?
It is also in.
Sorry, it's AS7. My attorney just corrected me.
Yes, it helps
And
if we know the bundle.
ESCOM 16-697. It's in
Okay.
the black.
Okay, okay.
It is also contained, Chairperson, in ESCOM Bundle 14.
I think my registrar already has bundle 16. 16, is that correct?
No, 14.
If it does appear there as council indicated, then we can use that one.
Okay.
Thank you. Yes, I've got the letter at ESCOM Bundle 16, page 697. It's a letter from McKinsey and Company, and it's addressed to Prish Govender at ESCOM. Just to refresh everybody's mind, it says, Dear Prish, authorization to pay subcontractor directly. That's the subject or heading. We refer to the professional services contract for the provision of consulting services for 6 months entered into between ESCOM SOC Limited, ESCOM and McKinsey and Company Africa Proprietary Limited, McKinsey, dated 29 September 2015, the agreement. As you know, McKinsey has subcontracted a portion of the services to be performed under the agreement to Trillion Proprietary Limited, Trillion. So in this letter, they make it clear in the second sentence that McKinsey had subcontracted a portion of the services to be performed under the agreement to Trillion. And then it says in the second paragraph, subject to 1, the terms of the agreement relating to any payments to be made by ESCOM to us, and 2, us issuing a written confirmation of our satisfaction with the relevant services to be performed by Trillion to McKinsey, and 3, the correctness of the amount to be invoiced. We hereby agree for and authorize Trillion to invoice and be paid directly by ESCOM for any services performed by it in pursuance of our obligations under this agreement. Okay. So, would you agree, Mr. Singh, that on the face of it, in that letter, second paragraph, Ms. McKinsey's agreement and authorization that Trillion be paid directly by ESCOM was subject to those 3 conditions? Do you go along with that understanding of paragraph 2?
Mr. Chair, I do, on the basis that it is forming part of the letter.
Yes, okay, all right. And then the next question would be, when ESCOM made the payment to Trillion, had these conditions been satisfied?
Mr. Chair, I think before we go and answer that question,
Yeah.
let us deal with the issue that Mr. Seleka had posed to me.
Yes.
Relating to the identity of the party that performed the services.
Yes, okay, deal with that and then come to this.
And I'm saying, given the content of this letter, in terms of sentences 1 and 2 of paragraph 1, it is clear that for all intents and purposes and at all material time, McKinsey understood that Trillion had been doing the work and there was a subcontract, they were a subcontractor to them.
I don't think that you necessarily need to misrepresent anything, but when you say at all material times, that might widen
Okay,
This
okay.
year.
All right. So at the date of this letter, Chair,
Yeah.
it would appear, not it would appear, it is factual that based on the paragraphs that I've read to you from Mr. Amankua's letter, Mr. Amankua's affidavit, as well as which results in this letter of 9 February, it is that McKinsey accepted that Trillion would be their subcontractor on the corporate plan work.
Let me make mention this, and then you can see how you deal with it. That last sentence in the first paragraph of the letter suggests two things. One, that McKinsey, at the time of the writing of this letter, had already subcontracted a portion of the services to Trillion. That's one. But two, but that the services were yet to be performed under the agreement. That might be a certain interpretation. Maybe somebody else might interpret that sentence differently. But my first impression was, it looks like they're saying, we have already subcontracted to Trillion, but that's for services to be performed in the future. But maybe what they meant is, at the time of subcontracting, the services were to be performed, but maybe they had already been performed by the 9th, I'm not sure. So I just wanted to deal with those things.
Mr. Chair, I would hazard to say it's your second interpretation, and I will tell you why I say so. Firstly, they reference the agreement, which can only be the corporate plan agreement, because they actually define it in the first sentence. Okay? And secondly, Mr. Amankua, in the passages that I've read to you, states that the date on which this letter was prepared in the process that I had taken you through, by that time, the work relating to the corporate plan had substantially been completed.
Okay.
If you recall,
Okay.
the corporate plan would have needed to be submitted by the 28th of February.
Yes, yes.
And this is around the 9th. So substantial completion was achieved by that time.
Okay, okay. Yes. Okay, all right.
Yes.
Mr. Seleka?
Yes, Chair, the chairperson's question about the conditions should not be
Oh, yes.
forgotten.
Oh, yes.
Yeah.
So hopefully, Mr. Chair, this put paid puts paid to the issue of whether the identity of the party relating to the corporate plan is still a mystery or not. In my view, it should not. In terms,
We will put everything into the
One
basket,
pot. Yeah.
into the pot, and
Yeah.
see what we come out with. Yeah.
Yeah, because Mr. Singh, we can't turn a blind eye to the correction they make, that the information was inaccurate. And the people who drafted the letter have since been disciplined or have left the firm.
well, Mr. Chair, the fact that the people,
Maybe let's not go back to it.
Yeah.
Let's leave it at this, that everything must be put into the pot to see what the real picture is. What you have said, the passages that you read in the affidavit, and what Mr. Slega referred to, everything will be looked at to see exactly what picture emerges.
yes, Mr. Chair.
Yeah,
I think, again, Mr. Chair, not going back to the issue,
yeah,
but the fact that someone has been disciplined, or someone has left the organization, does not detract from the fact that this is a legitimate letter.
yeah. No, I understand what you say. I understand what you're saying.
Coming back to the issue of, Mr.
The
Chair.
conditions.
The conditions. Mr. Chair, as I understand it, once Mr. Angel, once this letter was transmitted to
ESCOM.
to ESCOM and to Trillion, and after Mr. Angel's subsequent amendments to the letter was rejected, Trillion CFO, Mr. Labalo, issued a letter or an email to McKinsey requesting this sign-off in terms of these procedures. And I think the email had been sent to Mr. Lawrence Youngeling, a McKinsey manager or senior partner. And he then, in the email, basically said the sign-off should be sent to Mr. Edwin Mabalani. In terms of whether the sign-off was actually provided or not, I'm not too sure, but I know that a request had been made. In my affidavit, I do go to the extent of saying that Mr. Govender also engaged with Mr. Lawrence to understand whether this is approved by McKinsey or not. I don't have an email to prove that Mr. Lawrence had given the go-ahead, but maybe when Mr. Govender is requested for an affidavit, or when Mr. Govender appears, he can be asked, and Mr. Edwin Mabalani can also be asked in terms of what was the status of these conditions being fulfilled or not.
So your short answer is you have no personal knowledge whether or not these conditions were had been complied with by the time Eskom paid the money to Trillion.
No, sir.
Yeah.
Other than the documents. that
No,
are
in
provided.
this case, meaning yes, to my question. I said,
No, I did not.
Is your short answer that you have no personal knowledge of whether these conditions had been met by the time
Yes.
Eskom paid?
Yes.
Yeah. Okay, it's yes. Yeah, no and yes can confuse. Okay, all right.
Yes.
Mr. Selega?
Thank you, Chair. Just for the benefit of the chairperson, Mr. Singh, in the same affidavit of Mr. Amankwa, and I will not read this, Chair, unless when you look at them, you find them crucial.
Yeah, well, if you think it's important, you can.
Yes. Let's look at paragraph 7, Eskom Bundle 14. Eskom Bundle 14, page 702.191.
191.
Yeah, 191. It's just,
Take it that we won't be going back to this letter of the 9th anytime
No.
soon. So this
we can put aside.
can go. 702.191.
191, correct, Chair. Paragraph 7. And I'm concluding on this because
Yes.
remember Mr. Amankwa said the information in the letter is inaccurate because they didn't subcontract to Trillion, and to say otherwise would contradict information that existed at the time in that last paragraph we read. And he deals with that in...
Sorry, Mr.
Okay.
Chair. Can you just
Okay.
repeat?
He says in paragraph 21.7,
21.7.
yeah,
I'm sorry. You have moved from page 702.191 now.
yes, Chair, I thought... Sorry, Mr. Singh, what did you want? Let me ask you, what did you want?
No, you started speaking and I wasn't just listening.
Oh,
So I just said if you could just...
repeat
what you've
repeat,
said.
yes, okay. But you are on page...
You referred us to page 702.191.
That's
Mr.
right,
Selega,
Chair.
Paragraph 7.
Yes.
Yeah, what was the point about paragraph 7?
So before I read it, I want to underscore the paragraphs here by what Mr. Amankwa says,
So which are those paragraphs?
which is what he said in paragraph 21.7.
21 points.
Yes.
So that's what I was looking for. Okay.
Yeah, tell us what he says there, Mr. Selega.
Is where he says, it is inaccurate to say Trillion had been subcontracted, in their corporate plan as McKinsey subcontract. To say otherwise is not reconcilable with contemporaneous information. Yes. So that's the underscore. Then I go to this paragraph. You hear, Mr. Singh?
Yes. Okay, go to paragraph 7 then.
Then paragraph 7 deals with Regiment's role in the corporate plan projects. And there he deals with it. He says, 7.1, McKinsey was notified late in the contracting process in Eskom's acceptance letter of 29 September 2015 that McKinsey would need to outsource 30% of the corporate plan contract to a SDP, which is Supplier Development Partner. 7.2, at this time, Regiment's Capital, Regiments in bracket, a firm that had previously performed work at Eskom on a financial strategy, was viewed as a logical candidate to partner for the corporate plan. Regiment's prior track record at Eskom and his prior work with McKinsey positioned it to make an important contribution to the corporate plan. Then 7.3, in the end, however, there was no formalized relationship in the form of a contract with Regiments for work at Eskom on the corporate plan. Regiment reported directly to Eskom on its work, and McKinsey and Regiments largely worked on separate work streams, although McKinsey's consultants collaborated with Regiments on select issues. 7.4, Regiments worked on the financial part of the corporate plan that formed the funding plan chapter, which was work that was directly overseen by Eskom. And then he refers to the annexures. This was an extension of the financial modeling work that Regiments had worked on for Eskom on what I understand was on a pro bono basis. 7.5, McKinsey's decision to proceed with the corporate plan without a formal contract in place with a supplier development partner is an example of a mistake that should not have been made. Mr. Singh, I can read the entire paragraph. While it appears to have stemmed principally from the fact that Regiments was already working at Eskom on related work streams and was in the process of spinning off its consulting business, it is nevertheless regrettable. Although Regiment's work on the corporate plan was overseen by Eskom, the ambiguity surrounding the relationship between McKinsey and Regiments with respect to the corporate plan led to confusion among McKinsey team and allowed Regiments to undertake its work with less supervision from McKinsey that it might have received otherwise. This lack of contractual rigor is an example of the type of mistake McKinsey has sought to remedy with updates to its policies described below. But I've read this to you, Mr. Singh, to show that nowhere in these paragraphs he refers to Trillian, and he's explicit about who was intended to be the SDP, Supplier Development Partner, for McKinsey in respect of the corporate plan. And that is Regiment.
Do you want to say anything, Mr. Singh?
Indeed, Mr. Chair.
Yes.
Mr. Chair, in terms of the passages that is read by Mr. Saleka, firstly, I would like to point out 7.1. It is disingenuous of Mr. Amankwa to say that McKinsey was notified late in the contracting process, that Eskom would require an SD partner for work being performed at Eskom. This is not the first piece of work that McKinsey was doing at Eskom. So they know that there's always an SDL portion relating to McKinsey work. I mean, work at a state-owned company like Eskom. In terms of late, Mr. Chair, he signed, Dr. Weiss signed the letter of acceptance for the work, I think, on the 29th of September 2015, which indicated a 30% SDLN partner. So before that date, they could have not known that they were going to get this work because it was not approved. So how would we have told them before that? So it couldn't have been late in the process. The letter that he signed acknowledged that 30% had to be subcontract to an SDL partner. So that cannot be an acceptable statement that he made. In terms of the rest of the paragraphs that Mr. Seleka has read, Mr. Chair, again, if you look at paragraph 7.5, for example, McKinsey's decision to proceed with the corporate plan without a formal contract in place with a supplier development partner, doesn't say regiments, says a supplier development partner, is example of the mistake that should not have been made. Continues to the last sentence of this paragraph. The lack of contractual rigor is an example of the type of mistake McKinsey has sought to remedy with the updates to its policies described below. Now, Mr. Amankoa and McKinsey specifically try and obfuscate the obligation relating to the fact that they had a relationship with Trillium. Originally with regiments, and it morphed into Trillium. And for whatever reason that currently is playing out, whether it be political or reputational or otherwise, they are attempting to obfuscate the actual facts that were available at the time. And I will come back to paragraph 21.7, Mr. Chair, because it's now very convenient to say, although regiments worked on the corporate plan and was overseen by ESCOM, the ambiguity surrounding the relationship between McKinsey and regiments with respect to the corporate plan led to confusion amongst McKinsey staff and allowed regiments to undertake work with less supervision. Mr. Chair, I can understand if my kids were confused. This is the legal head of McKinsey South Africa. It is the head of the accounts department. 2 senior partners from McKinsey are involved in the process. Dr. Weiss has 2 PhDs, not 1, 2. Now you're trying to tell me that these individuals that were part of the process, that was involved on a daily basis, that met me almost on a daily basis, were involved in meetings relating to all of these projects, were all of a sudden confused and had ambiguity in their mind. To produce a formal letter that went through the rigor of the process I just explained to you. And now McKinsey is of the view that it was ambiguous. I cannot reconcile the two, Mr. Chair. If we go back to 21.7, which is on page 702.224, Mr. Chair, such evidence makes it clear that Trillium was not McKinsey's subcontract, because it was not contemporaneous with the information that existed at the time. Mr. Chair, I took you through the information that existed at the time. It is just convenient for McKinsey to now state that it was regiments that was doing the work at the time. There is no ambiguity, in my view. And I do not believe that McKinsey can claim ambiguity. If anything, Mr. Chair, if you look at the process that letter went through for it to be issued, and if McKinsey distances itself from that letter now, we should be asking the question, who actually committed the fraud?
Well, Mr. Seleka, there may be different points that need to be looked into with regard to the corporate plan, Trillium, regiments, McKinsey, ESCOM, and the payment that was made. But on the face of it, if McKinsey gave ESCOM a letter that said, you may pay our subcontractor Trillium directly, on the face of it, Trillian can't say ESCOM should not have paid, except insofar as they say, we did say ESCOM could pay Trillian directly, but we said if certain conditions were met, and ESCOM was not supposed to pay Trillian directly if those conditions were not met. So that the latter point, I understand.
Yes, Chair.
So I think that to the extent that there may be the question of, to the extent that the letter of 9 February may be seen as relevant to the question whether ESCOM should have paid Trillian directly, even assuming Trillian was McKinsey's subcontractor. The real question, it seems to me, would be whether ESCOM ensured that the conditions that McKinsey said should be met before ESCOM could pay Trillian directly were met. So that's how I see it.
Yeah.
If there are other points, one can take it from there. You have indicated that you don't have personal knowledge of whether those conditions were met or not by the time ESCOM made the payment. Maybe somebody else should tell us whether they were met.
Chair, if I may, before we take the lunch agenda,
Yeah.
I think, Mr. Singh, to add to what the chairperson is saying, the other factor I think, Chair, to be looked at is the fact that the letter doesn't appear to have come voluntarily from McKinsey. In the sense of it didn't come without a prior request. It came on the basis of a prior request from ESCOM and Trillian. And you may want to answer the question, Mr. Singh, why did ESCOM make that request to McKinsey? But you, yeah.
Mr. Chair,
Yes.
I would just ask Mr. Seleka to repeat the question.
The question is, you made the point earlier when you gave the background or the context of the letter of the 9th, that ESCOM and Trillian asked McKinsey to provide the letter, as I recall what you said. And Mr. Seleka's question is, why did ESCOM ask for the letter?
Mr. Chair, I was not the guy, I was not the person that requested the letter, but I would assume that the letter was requested, as Trillian has indicated, that ESCOM required confirmation that the main contractor was happy that the subcontractor would be paid directly in terms of the content of the letter. And if you look at the emails that were attached to it and Mr. Amankwa's confirmation, that could only be the reason for the letter.
Yes, well, I Mr. Seleka, you can look at it and then pursue what you believe needs to be pursued. On the face of it, I would imagine that if ESCOM did not have a contract with Trillian, and Trillian was supposed to be McKinsey's subcontractor, Trillian should look to McKinsey for payment and not to ESCOM. And if Trillian approached ESCOM to say, please pay us directly, ESCOM, if it was thinking about agreeing to that request, would have been acting prudently, to say the least. Let us see whether McKinsey, with whom we have a contract, has any problem with that, in which case we would like to have something in writing. So when one looks at it in that way, one can understand, but it may well be, and you would know better, it may well be that there are other issues that you want to explore in relation to the request. So I just mentioned that.
Yes, no,
Yeah.
that's fine.
Yeah, but we should take the lunch adjournment now.
Yes.
I just want to say I'm keen for us to move away from the corporate plan.
Yes.
We have already spent a lot of time last time on it. But obviously, if there are passages in affidavits that are important or documents and so on, it may be important that at least we place on record which documents or which paragraphs in which affidavits I must have regard to when I come to deal with this matter, so that I can go to those documents, go to those passages when I consider the matter.
Yes.
So I'm just saying I'm keen that we move away to go and deal with other matters. But if when we come back, somebody feels strongly that there is something that needs to be mentioned other than saying, Chairperson, when you deal with this matter, please remember to look at that paragraph and that affidavit and that document, then let me know. Otherwise, in the afternoon, we could just do that exercise and move on to something else.
Indeed.
Okay, all right.
Thank you.
We will adjourn now. It's 1:10. We'll resume at 2:10.
Thank you.
We adjourn. Okay, let's continue.
Thank you, Chairperson. Chairperson, Mr. Anod Singh and his team wanted us to emphasize something that Mr. Singh said during the testimony about Dr. Weiss, that in his transcript, when he was asked whether it was, well, the question is, it was regiments that rendered services in respect of the corporate plan and not Trillian, asked by the evidence leader. His response was that, Chairperson, I wish I could give you a razor-sharp answer to that question, but I cannot. Is to emphasize that Mr. Singh, in saying to you earlier, that Dr. Weiss didn't have a clear answer to that question.
Yes, yeah.
Yeah, but from his affidavit, I was making a different point
Yes.
about who McKinsey intended to be the supplier development partner, and that it was in respect of the corporate plan. I mean, the turnaround program, based on that paragraph from Mr. Singh's affidavit.
Okay, all right. Is there a particular page in the transcript where we will find Dr. Weiss' answer that you have just told me about? If that could be mentioned on record so one can know where to find it
That's
in
right.
due course.
A person on, I don't know where exactly it is in the, so they're going to just show me on the bundle itself.
Yes.
So it's in the transcript on page 29 of the day 323, approximately line 8. Advocate Shaskason asked him, and am I correct that the supply development work that was done on that corporate plan was work that was done by regiments, not Trillian? Dr. Weiss answers, Chair, I would love to give you a razor-sharp answer onto this question. I'm afraid I cannot. I can just tell you what I experienced back at the time. And then
Okay. No, that's fine.
Just give the date, please.
it is on the 11th of December of 2020.
11th of December of 2020.
Yes, and as I said, it's day 323
Yeah.
of the transcripts.
Okay, no, that's fine.
Thank you, Chairperson.
Thank you, Chair. Mr. Singh, I'm going to move on. Good. Thank you, Chair. Chair, I'm going to move on to the Master Services Agreement, which is this corporate plan. And I start off by that paragraph, Mr. Singh, in Dr. Weiss's affidavit, paragraph 29 and 30.
What page, sir?
Remind me of the bundle and the
Yes, Chair.
page number.
ESCOM Bundle 14, bracket C, page number 690.
390.
690.
690.
Yes. Paragraph 29 and 30.
Yes.
Yes, we read it previously, but just to recap and then we move forward. The paragraph 29 reads, with the letter of acceptance in place, we had a signed agreement between ESCOM and McKinsey, and we began work on the turnaround program in January 2016. At the same time, we continued to work to finalize the services level agreement. Despite McKinsey's efforts, ESCOM delayed signing the SLA. I eventually received a signed SLA from ESCOM in late September or early October 2016. By then, ESCOM had terminated the turnaround program and had compensated McKinsey for our work. At that time, I did not expect that McKinsey would receive any additional compensation from Eskom. Paragraph 30, the SLA that I received was signed on behalf of Eskom as of January 7, 2016. After consulting with in-house counsel regarding the SLA, I signed the SLA on behalf of McKinsey as of January 11, 2016, which was the approximate date that McKinsey began to work on the project. I understood that Eskom's preference was that the SLA be signed as of the effective date, which was the date that we began work. I regret any confusion that this may have caused. So the SLA is the same as the MSA, Mr. Singh. Is that correct?
It was used interchangeably, that's good.
Say again?
I said it was used interchangeably.
Interchangeably, yes. So from these two paragraphs,
Sorry, sir, Mr. Chair, if I just can clarify that point.
Just say that again.
I said if I can also just clarify that point. It would seem that at some point in time, between Eskom and McKinsey, they had contemplated concluding a master services agreement, which is the MSA, and additionally SLAs, or service level agreement. So there would be an overarching master services agreement, and then basically underpinning the master services agreement, there would be these individual service level agreements, from what I understand. But eventually, it migrated into just
the same thing.
SLA.
Thank you.
So the the MSA would be like an instrument that would broadly regulate the relationship between
Yes.
the two.
Yes.
And then there would be under it
This-
specific agreements relating to specific matters.
Matters, as I understood it.
Yeah.
But I don't think it actually
Went that way.
went that way.
Okay.
And hence the interchangeable use of MSA and SLA.
Yeah. Okay.
Yeah, okay, I'm going to approach it this way, Mr. Singh. From what we're reading here, is that there was a delay on the part of Eskom in signing that service level agreement, that agreement. He then ultimately receives the signed copy in late September 2016 or early October 2016. And when he signs it, he gives it a date of 11 January 2016. But he's signing it at the very latest, maybe September, or earliest, maybe September, the latest October 2016. But then he says, by that time, Eskom had already terminated the turnaround program. And from the evidence in this affidavit, and Mr. Amankwa's affidavit, and from Mr. Mabelane's affidavit, that termination was by letter dated 16 June 2016. So on the evidence, it appears that before this agreement could even be concluded, it was terminated. Your comment on that?
Thank you, Mr. Chair. Mr. Chair, I think in responding, I would, in the interest of time, not want to traverse the whole issue of the 1034 document, which I think you and Mr. Koko and Mr. Seleka has traversed quite significantly in Mr. Koko's last appearance
Yes.
at the Commission.
Yes. As long as you don't feel that that's unfair on your...
No. I mean,
your
at the end of the
case,
day,
yeah.
it was what I had
Yes.
started in
Okay.
my
Yes.
previous sessions.
Okay,
I think
no,
it was
that's
further
fine.
amplified by Mr. Coco.
That's
and hence, in the interest of time, I won't
Yes.
repeat that.
Okay.
But it also does form part of our affidavit that we've submitted into the records, or will be submitted into the records
Okay.
as of today.
No, that's fine.
So from that perspective, the sentiments are aligned.
Yes, okay.
So in response to Mr. Seleka's question about an agreement not being in place, in terms of the 1034 document, there is a legally binding commitment between Eskom and McKinsey on signing of the SA. And that was done.
Just to remind me, when you say that, is that a reliance on the correspondence that was exchanged?
No, Mr. Chair.
A formal agreement? you are
There was,
referring to?
remember, there was a letter of acceptance
Yes.
that was signed by McKinsey
Yes.
and Eskom,
Yeah.
dated 6th December 2015. So that creates the legal obligation between Eskom and Eskom and McKinsey as of December. And that is the basis on which they begin work in January, based on the 1034 document. So that's the first response to Mr. Seleka.
Chairperson, maybe just to assist on the affidavit that we brought today. It is annexure AS3. We took the liberty of attaching it for you with the front page and the relevant provision that deals with it.
Yes, okay, all right. I don't believe I have the affidavit in front of me as yet.
No.
So that's fine. So, but my question, Mr. Singh, was this: when you say there was an agreement, whether you mean there was already a formal agreement as we know it, or whether you were saying there was an agreement because there was an offer and acceptance. That's the clarification I was looking for.
Mr. Chair, I'm saying there was an offer and acceptance.
Yeah.
Therefore, there was an
agreement.
An agreement.
Based on the offer and acceptance.
Based on the offer and
Okay, all
acceptance,
right.
which was the letter that was signed
Yes,
on the
okay.
6th of December.
Okay,
So that's
all
the first part of the response. Mr. Chair, then if you look at the next part of paragraph 29, and actually Mr. Vice concedes that the letter of acceptance was a binding, was binding on Eskom and Trans. He then says, despite McKinsey's efforts, Eskom delayed the signing. I eventually received the signed SLA from Eskom in late September or early October 2016. By then, Eskom had terminated the turnaround program, and I had compensated McKinsey for our work. Okay? So let's deal with each one of those. So, Mr. Chair, in dealing with it, I would have to refer the committee to, let me just check if I'm right. Page reference 743. 743. Let's just find it. And I hope I'm right.
Is that in your...
You mentioned the page you are looking for, isn't it?
743, yes, I am right, sir. So in the same bundle,
743 on the
Seven-
bundle 14C that we are dealing with.
yes, sir,
Page 743.
that's correct, Mr. Chair.
Okay. Yes, I've got it.
So, Mr. Chair, I will come to the letter just now. Mr. Seleka is correct in that the MSA was terminated via a BTC resolution, a board tender committee resolution, and that then empowered Mr. Mablani to inform McKinsey of the termination via a letter, and I'm assuming it's the letter that he refers to, which is 16 June 2016. Subsequent to that, Mr. Chair, there were various letters that were exchanged between Mr. Mablani and Mr. Weiss, or Dr. Weiss, regarding the termination, between, let's say, the 16th and the 28th, which is the letter in question, which is at 743. And the letter in question at 743, Mr. Chair, is the final letter. But our affidavit that we submitted this morning covers the other letters that transpired before then. But for the purposes of now, let's just cover the issue relating to the issues that appear on 743. Now, if we look at 743, Mr. Chair, it says Top Consulting Group MSA reimbursement of costs. That's the heading.
So this is a letter from Mr. Vikas Sagar
And Dr. Weiss.
and Dr. Weiss, that is from McKinsey, and it's addressed to Mr. Edwin Mabelane, Chief Procurement Officer at ESCOM, and the subject is Top Consulting Group MSA reimbursement of costs.
That is correct.
Okay, take it from there.
So you will see a note, Mr. Chair, that the letter refers to a previous letter of 24 June 2016. In the first
Oh,
sentence.
yes, yeah.
Right. So, Mr. Chair, just
You can read the relevant part if you want to.
just in terms of background,
Yeah.
the previous letters that Mr. Mabelane had sent to McKinsey, and you will see it when you see the affidavit, and we'll deal with it then. But just in gist, Mr. Mabelane terminated the relationship, and also in his letters referred to the fact that because of the termination, ESCOM will not reimburse them on a risk basis, but you will reimburse them on a cost basis, on a time and materials basis. Let's put it that way. And the exchange of letters prior to this letter related thereto, okay, which culminated in this letter. So this letter, Mr. Chair, basically is McKinsey's, let's call it, for a better, want of a better word, McKinsey's letter of demand, vis-a-vis
Mackenzie's letter of,
demand,
oh, yeah, okay.
in inverted commas.
Yes,
Vis-a-vis
yes.
the termination of
Yeah.
the master service.
Yes.
So, Mr. Chair, I'll read pretty much the relevant parts. It says we are very surprised that ESCOM is of the opinion that the cost-based settlement is a prudent mechanism to conclude a risk-based MSA with McKinsey. We have put 100% of our consulting fees at risk and have since 6 months not received a single payment to cover the risk taken. Now, 6 months referring back to December 2015 being the signing of the letter of acceptance. We have virtually an army of consultants working across the business at significant cost. This effort has yielded significant results for ESCOM, and we have delivered and generated impact far exceeding exceeding ZAR 25 billion to date. You will recognize that we dedicated a team for 6 months, starting on 6/12/2015, which is the letter of acceptance date, to negotiate the master service agreement that we finally concluded in January 2016. This agreement clearly outlines how McKinsey will be reimbursed, including in the case of termination. And then they go through each termination clause. If you would like, I would read them.
And only if it's necessary for the points you wanted to make.
Mr. Chair, the point that I would like to make is that if you take this letter, which is dated June 28, 2016, it is difficult to understand how Mr. Weiss, in paragraph 30, refers to a date in September when these things are concluded, yet he's signing a letter in June that references a January date.
You say there is a contradiction.
Well, I'm saying either one of these things are not
Yeah, one of them is not true, you say.
Yes.
Yeah.
And I'm saying this ostensibly is a letter that we received, again, I'm saying, in good faith from McKinsey, based on the facts that existed as of this date. Yet again, for matter of convenience, or I'm not too sure what motivates Mr. Weiss to say
Yes.
he signed in October.
So the point you are making is there is talk of a termination mid-year 2016.
Yes, sir.
But in terms of Dr. Weiss' affidavit, he said he signed the agreement late in the year,
In October.
but backdated it because he believed that's what ESCOM preferred. Is that right?
Mr. Chair, I think what I'm trying to say is the date on which Mr. Weiss backdated, or the date on which Mr. Weiss asserts or alleges to have backdated the agreement in October, I'm saying cannot be.
Yes,
because he signed a letter that
Yes.
references the January date in June. Right? So there must have existed an agreement signed on the date of this letter.
no, I think I understood
Yes.
your point clearly. Yeah,
For-
you sought to say, how could he be signing the agreement in October when already mid-year 20 in June, he's talking about the termination
January date.
of the same agreement?
With the January date,
Yeah, with the January date.
which he alleges he inserted in October.
So you are saying that if he is right in saying he signed the agreement in October and backdated it to January,
This letter wouldn't have referenced the date.
he would not have, there would not have been talk of a termination of an agreement in June.
With a date that references January.
Yes, no,
Yes.
well, I'm not sure if I understand your emphasis on the date in January, because
Mr. J, what I'm
my
saying,
understanding, just hang on one sec. If he is right, that's, I think, the point you're making. If he is right that he only signed the agreement in October, then that means as at June, there was no agreement.
That is
And therefore, nobody could talk about the termination of an agreement that didn't exist in June.
that is correct, Mr. Chair.
Yeah.
And
okay.
I'm using the date of
Yeah.
January to come to the conclusion you've come to.
Yes, although I don't follow that, your part of referring to that.
Chairperson?
Let me-
Once you accept, just one second, because whether the date was
Now, let me explain to you, sir.
was May or whatever, as long as in June he had not signed,
But let me,
there was no agreement to terminate.
but my point, Mr. Chair, is that he alleges that he signed the agreement in October and backdated it with a date of January. In October. Okay?
Yeah.
Yet in June, there is a letter that is signed by him that references the very same agreement that he says he only signed in October and backdated to January. So I'm saying, when he drafted this letter in June, how would he have known the date of January if he only signed it in October?
Yeah, no, I think, I'm not sure that your emphasis on January makes much difference, but I think the importance of your point, as I have said, is on his version, if he signed in October, then there was no agreement in June. And if there was no agreement in June, how could he be writing this letter?
Correct, Mr. Chair.
Yeah, okay. Counsel, you are done?
I just wanted to, I think the point that my client's trying to make specifically refers to paragraph 2 of the letter.
Yes.
Where he states emphatically that the agreement finally was concluded in January of 2016. So he states it as a fact.
Oh, okay, yes, no, then that's different, yeah, that's different, yeah. Then you are not, your reliance shouldn't be about backdating.
Yes, yes.
Your reliance should be about what he says here.
Here, yes.
Yeah, okay, no, that's fine.
So
yes.
I'm saying again, Mr.
Yeah.
Chair,
You're
for a matter
saying what he says in his affidavit when he says he signed the agreement in October is contradicted by what he says here.
Here.
When he says the agreement was concluded in January 2016, speaking in June.
yes,
Because in June, if he had not signed the agreement yet on his version, he couldn't talk about the agreement having been concluded in January.
that is correct, Mr. Chair.
Yeah, okay, all right. Mr. Selega?
I haven't finished
Oh,
my
you are
answer.
still continuing, yeah.
Yes. So those are the first two responses to Mr. Seleka's question relating to the fact that it would seem on McKinsey's version that a MSA did not exist pre-termination, 16 June. And I'm saying another point to consider, coming back to the issue that McKinsey is a global firm. Mr. Chair, again, if you look at the testimony of Mr. Weiss, Dr. Weiss, sorry, Mr. Amankua, Mr. Mizala, Dr. Fine, I think those were the guys that testified from McKinsey. And maybe not too much Mr. Fine, but certainly the other three. They go on record and state the extent to which, and even this letter goes out and states it, the extent to which McKinsey was taking a risk, not only relating to the fact that there was no signed contract or no signed SLA, on the fact of the magnitude of the project being 100% at risk in terms of a MSA, zero success, zero payment. Okay? Now imagine in a firm such as McKinsey, you go and undertake this project, you don't have, according to them, you don't have a signed agreement in place, and all of a sudden the client gives you a termination notice. Given the exposure that they have taken, Mr. Chair, in my view, in my considered and professional view, it is inconceivable that this thing would have not triggered alarm bells from the people that were sitting at ESCOM right through to someone in global, because of the size, magnitude, and risk relating to this contract. So my view would be that when this termination letter landed at ESCOM, or was given to Mr. Weiss, Dr. Weiss, Dr. Weiss's first reaction would have been to take it to legal.
Have been to?
Take it to legal.
Yeah.
And say, listen, we've got this termination thing. This termination letter from McKinsey, from ESCOM. It is our biggest project in Africa, and it's now been terminated. The legal guy's response to Mr. Dr. Weiss would have been to say, fine, bring me the agreement. Because what is the legal guy going to do if there's no agreement? So it can't be, in my view, that when this termination notice was served, that everyone in McKinsey just left Dr. Weiss in his little corner to do as he pleased with this significant exposure that McKinsey had.
I guess also you may be making the point in due course, if you are not already making it, that it looks like this is at least the second letter from McKinsey where they write one thing in correspondence, but in affidavits seem to say something that contradicts what they have written in correspondence.
It's completely different.
Because there was the letter of the 9th
Yes,
February that we were talking about,
that is correct, Mr.
except insofar as, with regard to the letter of the 9th of February, insofar as they may have said, our authorization or agreement that you may pay as ESCOM, you may pay Trilliant directly is subject to the fulfillment of these conditions. Except for that, there are other things in that letter which you say they seem to want to deny or run away from in affidavits.
That is correct, Mr.
And you say, certainly here, the correspondence of the time says one thing, but in affidavits that they have signed subsequently, they seek to say something else. Is that right?
That is correct, Mr. Chair.
Okay, all right.
And again, Mr. Chair, at the end of the day, if you look at this letter, there is no way that McKinsey would send us a letter like this if it had not gone through corporate legal within McKinsey itself. And basically, they are here saying that they request that ESCOM basically applies the termination clauses, which will give rise to the claim of 2.8 billion that they would claim under the MSA.
Of course, if McKinsey received a letter from ESCOM purporting to terminate an agreement, and if they, that is now on 24 June 2016, and if they didn't know that there was an agreement between them and ESCOM on the particular subject, they would have said, what are you talking about?
That is correct,
We
Mr.
don't
Chair.
have an agreement yet.
Or they would have said, if Dr. Weiss's version is correct, they would have said, we understand that these things are not concluded. They are not, can we
Yeah.
find a suitable way to conclude these things, an arbitration or an investigation or something?
Yeah, but certainly they wouldn't receive a letter saying we are terminating an agreement, and they thought there was no agreement, but respond as if there was an
As an
agreement.
agreement, exactly.
Mr. Selegai?
Thank you, Chair.
Well, I'm assuming, Mr. Singh, you had completed or you still had some points to make?
Well, Mr. Chair, if Mr. Seleka wants me to cover the other aspects of the paragraph, I can do that.
Yeah, I think
Of
you
this-
should cover yourself by making sure you have responded to everything that you need to respond to.
Sorry, Mr. Seleka, that page in the reference again?
You want the reference to the paragraph?
690, no?
29 and 30.
Yes. So, Mr. Chair, if we go back to paragraph, page reference 690,
What page?
690,
Okay. Yes.
if we then look at the second last sentence of that paragraph, Mr. Chair, which
Paragraph.
reads, by then,
Paragraph 30, paragraph 29.
sorry, paragraph 29,
Okay.
it says, second last sentence, it says, by then. Are you there, Chair?
I am at paragraph 29. I'm just looking for, yes, I can see it by
Says,
then.
by then, ESCOM had terminated the turnaround program and had compensated McKinsey for our work. So, Mr. Chair, again, if Mr. Dr. Weiss, actually, Mr. Weiss is factually correct. We had terminated the agreement and we had paid them because he's referring to a date of October in this affidavit. And the first payment we had made to McKinsey under the MSA, if I recall correctly, was sometime in August. So we had terminated and we had paid. Okay. But the important point, Mr. Chair, is if you look at all of the correspondences, whether it be any of the affidavits from Dr. Weiss, Dr. Weiss refers to it, but he doesn't explicitly refer to the point that I'm going to make. Mr. Mizala refers to it, but also doesn't explicitly refer. Mr. Amankoa doesn't refer to it at all. In the court papers between ESCOM, McKinsey, and Trillion, they don't also raise this point. And the point that I'm trying to raise is, if now Dr. Weiss is referring to the fact that there was no contract, then equally, just like Trillion was paid without a contract, McKinsey then was paid without a contract for the August payment. Yet no one in any of the legal documents seems to rely on the fact that McKinsey was paid without a contract, and therefore they should refund the money.
Yes. Yeah, no, I mean, if you say in August, McKinsey was paid in regard to this work, and Dr. Weiss says the agreement was only signed by McKinsey in October, it means in August, when they were paid, there was no agreement. That's what it would mean, and that's the point you made.
That I'm making.
Yes.
And nowhere does anyone rely on that specific point.
What is the implication of the fact that in that sentence that you have just read, Mr. Singh, Dr. Weiss talks about the termination of the turnaround program as opposed to the termination of the agreement? Is there Is he using those terms interchangeably?
Mr. Chair, I think he's using them interchangeably.
Okay, all right.
Then,
Chair,
Mr. Chair, if I can continue.
No, can I just comment on this one?
Yeah, yes.
Because I think he's not necessarily using them interchangeably.
Okay, okay.
It's because the turnaround program, Chairperson, was going to be rendered pursuant to the SLA.
Yes,
So I think he's using it deliberately to
Yeah.
distinguish between the two.
yeah,
Because on his version in the affidavit, the SLA had not been concluded. So what got to be terminated was their services as rendered in terms of the turnaround program. Because he does say they had already started rendering services. So I think it's a deliberate use of words or choice of words there, Mr. Singh.
Chairperson, with the greatest of respect to my learned friend, if you look at the letters, it specifically refers to the MSA. Now, my client has alluded to the fact that there's other letters that precedes us. We've attached them to our current agreement, but they all consistently refer to the MSA. So there can be no doubt that they're referring
Okay.
not to a program, but to an agreement.
okay, okay. Let Mr. Singh be the one to deal with that. Mr. Singh, what do you say to Mr. Selega's proposition that Dr. Weiss is deliberately talking about the termination of the turnaround program here because he knows that there is no agreement at that stage?
Mr. Chair.
Of
in
course,
my-
I see that in the previous sentence, he talks about October 2016, and then he then says by then, which must mean by October 2016. Yeah,
Chair, sorry, Mr. Singh. Look at how he starts paragraph 29. He says, with the letter of acceptance in place, we had signed an agreement between ESCOM and McKinsey, and we began work on the turnaround program in January 2016. He says, at the same time,
that he talks about there. Which one, which agreement is he talking about?
yeah,
On your understanding?
it's this acceptance, and I suppose it is the acceptance, but because I want to, you will see how he deals with it in the second paragraph, I mean, not paragraph, but sentence. He says, at the same time, we continued to work to finalize the services level.
So which agreement is he talking about in the first line of paragraph 29? That he says had been signed.
Yeah. According to my understanding, he's specifically referring to, as Mr. Singh is saying to the chairperson, the letter of acceptance.
But he wouldn't, the reference to signing an agreement
Yes.
contemplates, as I understand it, where there would be a single document that is being signed,
Yes.
as opposed to an agreement that's constituted by the sending of an offer and the sending of acceptance, which are signed separately.
Correct.
So if that understanding is correct, what agreement was he talking about in the first line?
That's correct. I mean, one will have to see whether they canvassed this with him during his evidence
Yeah,
when he was here on the 11th of December 2020, Chair, and how it was dealt with.
Mr. Singh, what would be your understanding of what agreement he's talking about in the first line of paragraph 29 when he says, with the letter of acceptance in place, we had signed agreement between ESCOM and McKinsey and we began work on the turnaround program in January 2016. The letter of acceptance would have been, just remind me, Mr. Singh, the letter of acceptance would have come from from ESCOM,
Yes, sir.
and it would have been sent to McKinsey.
That's correct.
And when it was, did it have two places for signature
That is correct.
by McKinsey and by ESCOM? Okay, if it had that, then one could talk about an agreement being signed. Maybe one could talk versus it's a single document. It's signed by both sides, both parties, and it may well be that Mr. Seleka is right in his understanding that the agreement that he's talking about there is the agreement as constituted by the offer and acceptance. You would go along with that?
Mr. Chair, I will.
Yes, yes. Okay, at least that part I understand. Okay, I think you were still wanting to go on to make some points, Mr. Singh, or had you finished?
I think, Mr. Chair, it was just in response to
Mr.
Mr.
Seleka.
Seleka's, or I think it was your question, Mr. Chair, that the termination, is there a distinction between terminating the turnaround program or terminating the SLA? And I said, I think it's used interchangeably.
Yeah,
and I
yeah,
think Mr. Seleka
yes,
then went
yes.
to
Yes,
this part to
yes.
try and explain that it's probably not used interchangeably.
Yes, yes,
Okay.
yes.
In my view, Mr. Chair, it's a moot point if we accept that the 28th of June letter could not exist, as we've just explained. Okay. So whether he's terminating the turnaround program now in the context of this, of this date, which is October, it's a moot point. Mr. Chair, in terms of the next sentence, where it says, I did not expect that McKinsey would receive any additional compensation from ESCOM. Mr. Chair, again, that is contrary to the actual events that transpired. Because McKinsey then entered into a settlement agreement with ESCOM, dated February 2017, that enabled them to get further payments. So if this was true, Dr. Weiss should have not signed the settlement agreement, or engaged with the settlement process that started sometime in, well, started with this 28th of June letter, well, actually started with the 16th June letter, and ended with the 17 February, I think it was, settlement agreement. It was signed between ESCOM and McKinsey. So again, I'm not too sure why Mr. Weiss is stating these things, but I guess he can explain if need be.
Yes.
You did do the paragraph 30 as well, Mr. Select.
Yeah, I do it.
Again, Mr. Chair, if you will see, Dr. Weiss qualifies in paragraph 30 the fact that the SLA I received was signed on behalf of ESCOM as of 7 January 2016. That's the first sentence. And then he says, after consulting with in-house counsel regarding the SLA, I signed the SLA on behalf of McKinsey as of January 11, 2016, which is the approximate date that McKinsey began the work on the project. Now again, there is reference to in-house legal counsel. Now, I cannot believe, again, that he would refer to in-house legal counsel in October, yet he's issued a letter in June saying that there was an agreement, or concluded agreement. It would have been more likely that he actually engaged with in-house legal in June, because that's when he actually had prepared the letter for termination.
Could it be that there is confusion, and confusion is created by the fact that at a certain level, McKinsey talks about an agreement having been signed on the basis of offer and acceptance, and then talks about a formal agreement, as I understand it, a formal agreement not in the context of for an offer and acceptance, but a normal agreement
Mr. Chair, I
being
find,
signed by McKinsey in October. Is it not two transactions or two documents? Maybe they relate to the same transaction, but first you have an offer and acceptance, which in law could constitute a contract, but then there is a desire to have one document that reflects all the terms and conditions of the agreement. And that process comes after the signing of the acceptance by both parties. And that is what comes later. But should the situation arise where, for some reason, the formal agreement is not signed, any one of the parties can still say, based on the offer and acceptance, we did have an agreement, and this is what I did under that agreement, and I should be paid this or that or that.
Mr. Chair, that is the version that McKinsey would prefer you to accept or to believe. And I find that very difficult to, in my own mind, accept. And the reason, therefore, is, Mr. Chair, if you look at the June letter, it doesn't refer to a letter of acceptance. It refers to a signed MSA.
But you have a version that also goes along with the idea that once there was an offer and acceptance and the signing of the acceptance, there was an agreement.
No, I agree, Mr. Chair.
Yeah, you agree
I
with that
agree
part.
that there's a two-step approach.
Yes,
In
yes.
terms of originally,
Yeah.
there would have been a legally binding agreement on the
Yes.
acceptance, on the signing of the acceptance letter.
Yes.
Okay? But the point that Mr. Seleke is trying to raise, or is trying to make, is that the date on which there was termination, there was termination of a non-existent contract.
Yes, but if we were to go along with the idea that a contract came about when there was an acceptance of an offer, then in June, there would have been an agreement, isn't it?
Correct, Mr.
And why don't we look at whether the termination we are talking about, that they are talking about in that letter of June, relates to the termination of that agreement as constituted by the offer and acceptance.
Let's go there, sir, Mr. Chair. It's 743, I think.
So in other words, what I'm in trying to establish what really seems to be confusing, I want to see whether if we follow that line, that approach, the whole thing doesn't begin to make sense or not.
Agreed, sir. So we go to 743, Mr. Chair.
743. Yes.
Which is the letter of 28 June.
Yeah. Where is the letter of termination?
Chairperson, ESCOM Bundle 14.
Yeah. Maybe I just want to look at that first.
Yes.
What page?
Page 877.26.
877.
Yeah, 877.26.
Eight seven six seven.
877.26.
Yes. It's a letter from Mr. Edwin Mabelane, Chief Procurement Officer, and it's addressed to Dr. Weiss of McKinsey and Company, and it's dated 16 June. Oh, this one is dated 16 June 2016, not 24. But let me see this one. It is a letter of termination, it seems. This letter serves to officially notify McKinsey and Company of a board decision taken on 9 June 2016 to terminate the McKinsey risk-based contract. You are requested to engage with Mr. Prish Govender to discuss the pertinent issue to give effect to the board resolution. In conclusion, ESCOM will embark on a transparent procurement process to reallocate the activities under the risk-based contract. McKinsey and Company is welcome to participate in this process. That risk-based contract could fall within, I mean, the contract, if there was one, that would have come about as a result of the offer and acceptance, could fall within this term, isn't it?
Mr. Chair, if you look at the heading,
Yeah.
maybe it'll,
The subject line, Chair.
the subject line, it says termination of top consulting group MSA.
MSA.
MSA. So
Oh,
this risk-based contract refers to the MSA.
Refers to MSA.
MSA, which was
Okay,
the-
so-
which was
so
the MSA
That's not what we are looking for. Is that
No,
right?
that's the one, Chair.
No,
It
that's
is
the
what
one.
we're looking for.
Yes.
Yes.
Okay, but, okay, you know, these contracts have got different names.
No,
Now, the one that Dr. Weiss says he signed in October,
Yes, Mr. Chair.
was it the MSA or the service level agreement?
So, Mr. Chair, as I explained originally when we started the topic, the MSA slash
Was
SLA
overarching.
was used interchangeably. But what they eventually signed, whether it be January,
Or
June,
October,
or
whatever.
October,
Yeah.
was the SLA.
SLA,
An SLA was signed,
yes.
but they interchangeably use it
They
in
refer to it,
conversation
yeah.
as SLA, MSA,
MSA.
risk-based contract.
Okay.
But effectively, it's the SLA that was signed either in January,
Yes.
June, or October.
Okay, so
And there
on,
was, in December, a letter of acceptance that was signed by both McKinsey and
in
ESCOM,
December 2015,
2015.
Yes.
So, Mr. Chair, those are the only two, let's call
Yeah.
it, contractual documents
yes.
that exist.
Okay, okay, so the offer and acceptance also referred to MSA.
Where is that one?
You know, that correspondence that we talked about.
We'll find it for you now, Mr. Chair.
In other words, the subject matter was the same.
Page, can I give the chairperson the page
Yeah.
number? 811.111.
811.
811.
111. I see this. Mr. Singh, you might have the signed one by McKinsey. This one is only signed by Mr. Edwin Mabelani.
Oh, yeah, maybe I do, I don't
In your annexures.
know. I think we may have that one.
Person, can we just all get on the same page? I don't know what my learned friend is referring to at this stage. Maybe you can just guide
The
us.
acceptance letter, page 811.111.
Okay,
Yeah, ESCOM bundle 14. ESCOM bundle 14C.
yes, I've got 811, page, what, you say 112?
No, 111.
111.
Yes. Mr. Singh, you are there?
Sorry?
You are there.
Yes, I am.
Okay, okay. That's the letter of acceptance. But where is the part signed by McKinsey?
Yeah, I see in the bundle, the investigators have this one, which is not signed by McKinsey. And I was asking Mr. Singh whether the one which is attached to his affidavit of this morning is signed by both parties.
This doesn't form part of our resubmission.
Or you don't have this.
Oh, okay, but we know whether there is a letter of acceptance that has the signatures of both parties in the same document.
Chairperson, maybe just for the record, I don't think for purposes of your discussion, it would really make a difference if you look at the one that's not signed. I think what you're interested in is what exactly is stated in the letter of acceptance, whether it can be construed as an agreement or not, vis-à-vis the points that you raise. And I think for that purpose, you can look at the one that's
Yes.
signed by only one party.
Yes, but I'm now going back to an earlier point that I'd made. You remember, Mr. Singh had said to me, in response to a question I put to him, that the parties had signed the same document in terms of letter of acceptance. And that kind of answered my query. But if factually that is not the case, it might revive that concern.
Chairperson, in fact, Dr. Weiss refers to it. He says that they've signed the letter of acceptance in December of 2015.
Yes,
On
no,
the
no.
17th of December 2015. As I say, my learned friend might not be able to lay his hands on the actual signed one, but you can accept it for a fact. That's what he stated, that there was a signed letter of acceptance by the same day that they got the offer.
Yeah.
They signed the acceptance, and that's the 17th of December
Yeah.
2015.
Well, maybe somebody will have a look and then we can take it from there. Let's move on in the meantime.
Yes. Chair, the investigator is checking exactly that.
Yeah, okay, all right.
The chairperson's second point, or I think Mr. Singh,
Mr. Chair, you were looking to understand whether there was a correlation between the letter of acceptance,
Yeah,
and the
given
letter
that
of
it was
termination.
signed by both parties, equals an MSA or an SLA,
yes.
or what was contemplated
yes,
by
yes,
it.
Yes, yes.
So if you then look at basis of acceptance, Mr. Chair, you will see we accept your proposal for the
What was the page of that letter again?
sorry, Mr. Chair, you are now at 811.111.
Oh, okay. I've got it, yes.
Yes. If you look at, it's addressed to Dr. Weiss, McKinsey and Company, notification of acceptance for provision of consultancy services, basis of acceptance. We accept your proposal for the provision of consulting services concerning the top engineers program on the terms and conditions generally agreed in the draft contract recently negotiated between McKinsey and ESCOM. Okay? So what you will find, Mr. Chair, as a common theme is that whether you refer to MSA or SLA, it always encapsulates the top engineers program.
Yeah.
So
yeah.
that is a thing that will string along across all of these.
Okay.
So when you go back to your termination letter, which is at 877.26,
Yeah.
you will see it says in the subject line, it says termination of top consulting group, which is top engineers program, and then it says MSA, or it could have said SLA,
Yeah.
which is basically, and then in the body text, it refers to McKinsey risk-based contract, which again is the other colloquial term that
Yeah,
we've used,
MSA.
MSA,
Yeah,
which was the
yeah.
risk-based contract.
Yes.
So this is
So-
the common theme throughout.
So going back to one of my earlier questions, what do you say to my thinking that the termination of the agreement that both parties, ESCOM and McKinsey, are talking about in June 2016 could be the termination of the agreement that came about as a result of the acceptance of the offer. What would you say to that?
Mr. Chair, then we were then going to page reference 743 before you, Mr. Chair, took us to the
Yeah,
letter
yeah.
of termination.
Yes.
So I think we've now established that there's a link between the letter of acceptance, between the letter of termination, and now we come to this letter of 28 June
Yes.
2016, which in
Responding
essence,
to the letter of termination.
which, yeah, responds to the letter of termination. And
Yes.
this, I think, will be able to answer your question
Yes.
as to whether it's one or both or
Yeah.
where does it lie.
I am there. What do you say about it?
So, Mr. Chair, if you look at the second paragraph, it says, you will recognize that we dedicated a team for a period of 6 months, starting on 6/12 to negotiate the master services agreement that was finally concluded in January. So basically, it does not refer to a letter of acceptance in this case. It is very specific in that it refers to the master services agreement. And again, if you look at the subject line, Mr. Chair, it says Top Consulting Group, MSA, reimbursements of costs.
So you are saying that that second paragraph doesn't or reveals that the termination was not a termination of an agreement that came about simply as a result of the offer and acceptance, but they are talking about the termination of an agreement that was concluded subsequent to that letter of an acceptance.
Mr. Chair, that's what I'm saying.
That's
That is
what you're
correct.
saying.
That is what I'm saying,
Yes.
Mr. Chair. Because
Yeah.
on objective fact, both ESCOM and McKinsey signed
Yeah.
the SLA.
Yes.
Except
yes.
that we
Yeah.
are now trying to establish when was it actually signed.
And is one of the points you are either saying or implying that when Dr. Weiss says the agreement SLA or MSA was signed by them in October 2016, that can't be true? Is that one of the points you make? Because of all of these discussions and correspondence, he couldn't be talking about an agreement that was concluded in January 2016 other than the MSA agreement or SLA.
That is correct.
That's what you are saying. Yeah. Okay, but we are on the same page that when you were talking about an offer and acceptance, which brought about a contract, the subject matter of that contract would have been the same as this one.
I agree, sir.
Yeah. So once this one was signed, I would imagine it replaced whatever contract may
Preceded.
have come about because of the offer and acceptance.
Acceptance.
Yeah. So you are saying before there was a formal MSA agreement signed in January 2016, there was a contract based on the offer and acceptance and the correspondence, but the parties contemplated that there would be a formal agreement. There was a formal agreement. It was signed in January. And support for that is to be found in this letter from Dr. Weiss himself, which doesn't talk about there having been no contract signed by this time of this letter, because if his version that he only signed, or McKinsey only signed the agreement in September, he would not be talking like this in June.
Well, Mr. Chair, on the objective facts relating to the letter, that's the only conclusion I can
Yeah,
come to.
yeah. Okay, all right. It feels like I'm following what is happening.
Yes.
But you might say, well, we will change. You might change what you are thinking because there are other documents or other evidence. But let's continue.
Yes, no. Safe to say, Chair, that the way I followed Mr. Singh, at the most he was prepared to say to you, there's two versions, one of them must be false. Either in this letter or in Dr. Weiss's affidavit. It's just that I hear the chairperson saying to Mr. Singh that he's saying the one in the affidavit is false. That I think he was, as I followed him, prepared only to say one of the two must be false.
Well, he might at that stage have said so, but with all the discussion, he might have made up his mind which one is false. Mr. Singh, have you made up your mind which one is false or not yet?
Mr. Chair, as you quite correctly concluded, Mr. Chair, it would seem that for sake of convenience, McKinsey moves between versions in terms of affidavit, when it's required to commit to an affidavit versus what was committed on evidence during a previous time.
But Mr. Selega says earlier on you were not sure which one was false of the two versions.
Well, Mr.
that
Chair,
I was
on
saying.
objective evidence,
But
I
he
would
says
suggest-
he thinks you are now saying there is a particular one that's false.
Mr.
And I
Chair-
just want you to clarify.
Mr. Chair, on objective evidence, as I've just said, if you look at the letter and you look at the contents of paragraph 29, I'm saying this is patently false. If you look, and I've said it on not only in terms of the termination, but also into the fact that Mr. Vice says he did not expect any other compensation. Yet he then received compensation and he signed a termination agreement.
Yes, but Mr. Singh, if you are not sure yet whether you are choosing which version is false, you don't have to say so now.
Okay.
I think Mr. Selega just wanted to have clarification, and I wanted to have clarification too,
Yes.
whether you have reached a point where you say, this is the false version, or you say, look, I'm not sure yet, but one of them is false.
Yes.
Is that where you are, Mr. Singh? One of them is false, you are not sure which one?
No, Mr. Chair, I'm saying that I believe that this one is, based on what I've read in the letter,
Yeah,
this does not make sense to me and this should be false. It
the
has to be
version
false.
that he signed in October
Yes.
is
Doesn't-
false.
Because I don't find any other correspondence, Mr. Chair,
Yeah.
that either exists in ESCOM or exists in all of the plethora of pages that we've gone through
Yeah,
that refers to a contract that was signed in October.
Yeah,
Mr.
Okay.
Bamalani, who's the subject matter of signing this document, also doesn't refer to a date in his affidavit
yeah,
relating to when he signed.
okay.
But based on the letters that he's received, Mr. Chair, because if Malani received this letter, and if he was of the view that there was no signed agreement, again, he would have said that there was no signed agreement, so
Yeah, no, that's
why
fine.
are we relying on a
Yeah.
termination clause?
Yeah, don't motivate further because we have covered the ground.
Yes.
Okay, Mr. Selega?
Thank you, Chair.
You had completed the points you wanted to make, Mr. Singh, or had you not?
Mr.
In
Chair,
response to Mr.
I mean,
Selega.
just the last point in terms of the fact that, again, as you have said, McKinsey moves through these issues and they are quite critical issues, yet they write it off as confusion. Dr. Weiss, in his last sentence in paragraph 30, says, I regret any confusion that may have caused. Yet it is a fundamental issue that causes great anxiety and reputational damage and everything to people. And yet we write it off to confusion.
Yes, Mr. Selega?
Thank you, Chair. Chairperson, just to emphasize the point, I think as you follow the trail of documentation, the acceptance letter is 17 December 2015. And apparently it was countersigned by the parties on that date. What Mr. Singh has said in his affidavit is that the service level agreement / MSA was concluded in January 2016. This letter from Dr. Weiss says the same. In January 2016, to negotiate the master services agreement that we finally concluded in January 2016. Now, this is a letter of demand, Mr. Singh, by McKinsey. When Dr. Weiss, puts the facts in the affidavit, he explains how he signed the master services agreement, or when he signed. Now, I want to take you to your own letter, because the operative date here, or month, is June 2016. Remember, we showed you your letter of the 19th of February 2016, last time on your appearance. 19.
I'm sorry, Mr. Selega.
Chairperson, I want to go there.
I'm sorry, Mr. Selega, before you go there.
Yes, okay.
Please don't forget what you wanted to deal with.
Yes,
I've just remembered something that I needed to be cleared. You remember when we went to the letter of acceptance,
yes.
no, to the letter of termination. I had asked for the letter dated 24 June 2016, because in McKinsey's letter of 28 June 2016, which is at page 743, they say, many thanks for the letter dated 24 June 2016. But you said I would find that letter at whatever page you said, but that letter was dated 16 June and not 24 June 2016. And yet you said that was the letter of termination. So I want to raise the question, what's the story between, is there a letter dated 24 June 2016, or was that an error?
No, I think I was not answering your question, Chair.
Yeah,
Mr. Chair, I
Insofar
think-
as it relates to the 24th.
If I can just
yes,
add clarity, Mr. Chair. The letter on 743 does refer to a letter of 24 June.
yes,
The 24 June letter does exist. I'm not
Yes.
too sure if it's in the bundle,
yes,
but it's part of our new affidavit.
yes. Is it a termination letter?
Mr. Chair, if you recall when I introduced the subject, I said Mr. Mambalani correctly did terminate the MSA through a letter dated 16 June.
Okay,
He then sent subsequent letters between 16 and 28 June.
yeah,
And there are 3 letters, I think,
okay,
that follow the same train of thought
okay,
in terms of the fact that ESCOM has terminated
yeah,
and we're reimbursing you on a cost basis,
okay.
not on a risk
Okay.
basis. So that the other letters really just
So the termination letter is the
Is
one dated 16 June,
yes.
but there was subsequent
Subsequent letters.
correspondence, one of which is the letter of 24 June.
Exactly.
But it's more about
The basis
connected matters.
basis of settlement.
Yeah, okay. Okay.
So no
now
one
I
disputed
understand.
this, no one
Yeah.
disputed the termination.
Okay, okay. Okay, Mr. Selega, I think that has been cleared for me.
Yes, Chair.
Yeah.
Thank you, Mr. Singh, for that clarity. So, Mr. Singh, then, talking about this date of January 2016 being the conclusion date, and looking at Dr. Vasa's affidavit, last time we accepted to the bundle your letter dated 19 February 2016, which we paginated as 877.156. So it will be at the very end of ESCOM bundle 14, bracket C, Chairperson.
What page?
877.156.
What's the bundle?
ESCOM bundle 14, bracket C.
Well, the one I have won't have page 77. You say page 77?
877.
Yeah, no, it won't have. So it must be B, because I have C.
It might be D.
Is it B?
It might be D.
D?
Yes, D.
No, it shouldn't be D, because are the numbers not going up? Because
This-
this is C, and it doesn't have page 500.
877.
Oh, I'm sorry, maybe it does, I'm sorry. No, 77 it won't have because it starts at 600 and something. That is for bundle 14C.
Yes.
So if you are saying bundle 14, page 77, it must be another bundle, and it should be bundle A, I would imagine.
No, Chair, you have the numbers in a reverse order.
I have in front of me ESCOM bundle 14C.
Yes, go to the very last, to the end of it, Chair.
To the end of?
Of that very same bundle, ESCOM 14 bracket C,
I must go to the end.
to the very end of it, 877.
877.
Yes.
Yeah, but I've been saying 77 and you didn't say no, you said 877. That's why I'm saying it must be an earlier bundle. I thought you said 77.
Oh, no, I thought you heard me, Chair.
No.
Sorry. Sorry. It's
That's
eight-
why I was saying it has to be earlier than bundle C.
Yes. Sorry, I thought.
877. Okay.
877,
What, point what? Or
Point-
only that?
156. Yes.
156.
You don't have it. No, let me.
Why is this page not marked paginated? There is, the last page is 877.155,
Yes.
and then there is a document that comes after that, Exhibit U 33.1, but it's not paginated.
Which is.
And that's the last document. So it must have been slotted in at some stage, but your team should have made sure they paginated.
That in fact, Chair.
Is it ESCOM's formal request for information?
Correct, Chairperson. It should have been formally, the bundle should have been formally updated.
Will you make sure that it's done after we have adjourned?
Yes, I know that the message has been sent already, Chair.
Okay. Okay. Have you got it, Mr. Singh?
Mr. Chair, not in the reference bundle, but
But you have got it somewhere.
I've got a copy that Mr. Seneca
Yes.
has given us.
Okay, just make sure, Mr. Solega, that mine and the witnesses one, as well as, of course, yours, so that we all have the same thing and it's paginated.
Yes, and the chairperson had requested that the first page be separated so that you have two, the font is enlarged to have two of this
Yeah,
sheet in 2 pages.
yeah.
But Chair, I've made the request. Let me
Okay,
move on. Mr. Singh, in this letter, we traversed this letter of 19 February 2016 last time.
this is a letter from Mr. Anuj Singh, CFO of ESCOM, addressed to Dr. Alexander Weiss of McKinsey and Company, dated 19 February 2016, and the subject is Top Consultant Program, Risk-Based Contract Proposal and Negotiation.
Correct.
Yeah, okay, continue.
And it says, in relation to the above, ESCOM requests a formal response on the following items. ESCOM understands that the intended BEE partner to McKinsey is Regiments Group. Yeah, Mr. Singh, that itself speaks volumes. That you would have said so in this letter, in respect to the MSA. We also further note that Regiments Group is in a process of transition and that the ultimate BEE partner would be Trillion Group. ESCOM would like McKinsey to provide a response relating to an article published on page 9 of the Financial Mail, February 18 to February 24, regarding allegations associated with Mr. Mohammed Bobat, a former employee of Regiments Group. Second bullet point. Further to the above, ESCOM seeks a response to key issues raised by myself at a meeting with McKinsey that took place on 9 February 2016 relating to the objectives of the above-mentioned proposed contract. The issues are as follows. And the issues are listed there, Chairperson, 1 to 6.
Yeah.
And I will not read it. I'll go to what should be the next page, the last paragraph. It is your urgent response within 7 days on the above issues will be appreciated. The signing of the proposed contract is contingent upon the receipt of satisfactory responses to the above requests. And so, Mr. Singh,
Mr. Singh, these documents and letters and emails that you and McKinsey and them were writing are confusing. You were just saying that the agreement was concluded in February, in January, but now on February 19, you are still talking about the agreement still to be signed.
Mr. Chair, if I can add some...
Don't add confusion, please.
No confusion, Mr. Chair. Mr. Chair, if you
Give
recall...
clarification.
Yes, Mr. If you recall, Mr. Chair, when I was traversing this issue of when exactly was the, let's call it the SLA signed, because that's the document that was eventually signed. I said it was either signed in January, per the date, or it was signed by June, or it was signed in October per Dr. Weiss. So I gave a range of dates because...
Well, you say or October on Dr. Weiss'
On Weiss's
version.
Yes,
Okay.
And Mr. Chair, this letter is the letter, it's signed. On this date, there was a draft version of this contract that we had contemplated signing within 7 days or whenever. So, Mr. Chair, I do not concede that there was a backdate. I do concede that there was a backdating of the agreement of some sort on objective facts. Whether it was in October is what we are trying to establish. But on objective evidence, there has to be some backdate. And, Mr. Chair, the other point that I would like to raise, which is also in our, I think our new affidavit that we submit, is that you will recall that Advocate Saleka started the MSA by traversing the happenings at what was called the steering committee. Okay. Now, I think it's the presentation to the second steering committee that took place, that there is a slide that effectively envisages the signing of the MSA. I think it was by the 31st of March or some date. I think it's the second steer code. There's a presentation and there's a table there, and it says MSA, and I think it says 31 March or something or the other. So even that steer code minutes, Mr. Chair, envisages that there was something that was drafted and not signed as of that date of the steer code, but it envisaged a signing by the 31st of March.
Well, you see, earlier on, your evidence was in reaction to Dr. Weiss' statement in his affidavit that he only signed the agreement in October and backdated it to January. Your evidence was that the agreement either was or must have been signed in January. I understood that to mean even by him. In other words, this backdating from October, you were rejecting. Was my understanding correct? At that time, that's what you were saying before we came to this letter.
Mr. Chair, what I was saying is that the backdating occurring in October it was not possible, given the letter that existed on the 28th of June that said an agreement had been concluded in January. And then they go on to effectively list the termination clauses that they then rely on relating to that agreement that was concluded in January. So that was the point that I was trying to make there, is that if the agreement was only signed in October, he would be making reference to it, as you would have said. If it didn't exist on that date, then they would have said, but why are you terminating something that doesn't exist? Okay. So it was in reference to the existence of a signed contract by that date being the 28th of June. But I did not say that it was not backdated.
Yeah.
There was an element of backdating on both ESCOM side as well as McKinsey side.
You see, my understanding of what you were saying, and I thought that that letter of 28 June
Yes.
from Dr. Weiss was supportive of your version, because I understood you to be saying the agreement was signed in January. This whole story that he only signed in October is not supported by anything, you know. And then you remember that in the second paragraph of that letter
Yes.
of 28 June, he himself says the agreement was concluded in January 2016.
Yes.
So that's when I was thinking he is supportive of your version, because I had thought your version was the agreement was signed or must have been signed in January.
Okay. Let me
And this
clarify.
story about October is really not good enough.
Okay. So
But
let me.
what you are saying certainly now is that there must have been some backdating that happened.
There must have been some back on both ESCOM as well as McKinsey.
I was about to ask whether you say on both or only one side. Say on both.
Ostensibly, it had to be on both.
Yes,
Because
okay.
even in the steerco,
Yes.
which was chaired,
Yeah.
there was envisaged that the agreement would have been signed sometime in the
Yeah.
end of March.
Yes.
And those steerco documents were prepared by Mr. Governor and Mr.
Yes.
Mablani's inputs.
Yes.
So
yes,
they would have known the
Yes.
status of that document.
Yeah. Mr. Selega? So, the confusion doesn't get properly clarified, but we continue to try and understand what was happening here.
It would help, Mr. Singh, if you tell the chairperson the facts as you knew them, because clearly, on the basis of the facts you are now saying, the steering committee meeting of the 9th of February 2016, this letter of yours, and there will be another letter from McKinsey, 2 letters in fact. You would clearly have known that January 2016 cannot have been the month in which the MSA was completed.
If I can offer my view
Yes.
as to the response to Mr.
Mr. Selega, yeah.
point. You will recall that the SLA required, was basically in place and was, let's say, agreed to by the party.
Agreed to by?
Agreed to by the parties.
Yeah.
Okay. And the parties operated as if the SLA was in place.
Wasn't there,
No, was in place,
as if it had been signed,
as if it was being signed,
at a time when it had not yet been signed.
when it had not been signed.
Okay.
Okay. The agreement itself, the SLA, let's just use the word SLA. The SLA itself contained 2 suspensive conditions. And Mr. Seleka led evidence the last time to say, do you know whether these things were fulfilled or not? And my personal knowledge at the time was that I did not know. However, in our new affidavit that we'll introduce today, we've provided certain evidence to suggest why we believe those two suspensive conditions were fulfilled.
Were fulfilled.
Were fulfilled
Yeah.
as of the required date, which was the 31st of January. And those two suspensive conditions, Mr. Chair, was one, that a steering committee should be constituted. So in our view, we've provided a BTC minute from July 2015 that, in our view, constitutes the steering committee. We've provided an email, I think it was dated 26th of January, if memory serves, that effectively says, listen, these are the steering committee members. There's another email from McKinsey that says, listen, these are the steering committee members that must come from their side, as well as 2 trillion representatives. Then we attach a terms of reference relating to the steering committee that was agreed to between Eskom and McKinsey. So in our view, those documents indicate that by the 31st of January, the steering committee was constituted, albeit that it met on the 9th of February due to, as they identified in the emails, due to diary constraints. The second point, Mr. Chair, was that there needed to be auditor sign-off on something called the WAVE tool. Now, the WAVE tool is basically a McKinsey proprietary software that basically tracks these, let's say, risk-based contracts. And Mr. Chair, there we offer an email, well, it's actually an email as well as a report. The email basically, I think it is sometime in December 2015 dated, if I recall correctly. And it copies the head of IT, Mr. Sean Maritz. It copies 2 individuals from Eskom internal audit, and it is from the head of information security, I think, at Eskom IT. Now, the issue is that the suspensive conditions require auditor sign-off on the WAVE tool. So in my view, Mr. Chair, you find that Eskom internal audit individuals are copied in the mail. The individual that actually does the work is from IT and is identified as an individual called Mr. Vimal Naik. And he does a whole lot of work. It's in a document that's 6 pages long, and he basically says he's happy with the WAVE tool with certain reservations. He then sends that to the head of IT, Mr. Sean Maritz. And the internal audit individuals are copied in that mail. So to me, my understanding was that is what Eskom relied on to say that the suspensive conditions were fulfilled in terms of audit sign-off on the WAVE tool. In addition to that, Mr. Chair, we attach a audit report that was provided by McKinsey from audit firm Ernst & Young, which basically gives also some comfort around the WAVE tool and security measures in the WAVE tool and so on. So that is the basis on which we believed, or Eskom believed at the time, that the suspensive conditions were fulfilled. I'm assuming that that is the same view that McKinsey took at the time, because we continued as if the contract existed in terms of our behavior, because we set up the steer codes, we went on to do work, we did all of these things. So from that perspective, when we talk about the contract being concluded, or there being a contract that existed, it was on the basis that the suspensive conditions relating to the contract had been fulfilled. What remained thereafter, Mr. Chair, may have been the annexures or the schedules to the contract relating to certain initiatives, maybe the BEE partner, because obviously at that point in time, Trillion was still going through a vetting process and all of that stuff. So those may be things that were still outstanding, which prevented the formal signing of the agreement. But the parties operated as if the agreement or the suspensive conditions to the agreement had been fulfilled by the 31st of January. So that is the reason why Mr. Chair, we would say that the word concluded in January would be appropriate to use because the suspensive conditions relating to the contract was concluded in January.
Mr. Slogan.
Yeah. Thank you, Chair. But the preconditions, Mr. Singh, don't bear on the conclusion of the agreement. So I think your letter of the 19th of February is what it is. It was a proposed contract. You say the signing of it was contingent upon them satisfying those requirements. They responded to you in the letter of the 25th of February. And Chair, I should again apologize because the updates haven't been done. I don't know whether the chairperson will have that letter. It goes with this one we've read of the 19th of February.
What page did you say we must go to?
It's the next page, Chair.
Oh,
Yes.
well, it's the same situation.
It's the same situation.
Yeah.
I've paginated mine, I know, because I had to ask
Yeah.
to leave to have them admitted as exhibits.
Yeah,
But as the chair of that letter of the 24th of February 2016,
yeah, I've got the letter, so it's, and we admitted the document previously as Exhibit U 33.2.
that's correct.
So what remains is just the pagination.
Correct.
So this is a response from McKinsey
Correct.
to Mr. Singh,
Yes.
responding to Mr. Singh's letter of 19 February.
Correct.
Okay,
Correct. And there are certain relevant paragraphs here which might be which are of importance to you. And I want to go to this page 1, 2, 3, 4, which has paragraph in brackets 3 and 4 and 5. I would read bracket paragraph 4, Chairperson. Which is
yes,
the development of BEE partners as regards the vision, aspiration, skills, and competency mix. Mr. Singh, you have that in front of you.
Yes.
Thank you. It says, as described, competency mix and overall plan for success over the contract duration, including a focus on the health of the relationship with McKinsey. As described earlier in this note, the development of BEE partners forms an integral part of the overall program. As a supplement to the SLA, a whole memorandum was negotiated with the title Summary SD&L Discussion Results. In this memorandum, it is clearly defined how BEE partners should be developed. We are 100% committed to the result of the negotiations between Eskom and McKinsey with respect to the development targets. The following development philosophy management consulting partner has been negotiated. And then they talk about the philosophy there. Chair, I would like to cut to the chase. If you may go to the next page, where it says the selection after the bullet points. The selection of the management consulting partners will be fully aligned with Eskom. Besides Letsema, McKinsey pre-confirmed regiments and a company advisory as black management consulting partners. McKinsey is happy to qualify additional partners and will seek Eskom's advice and guidance in this matter. For an instance, black consultancies listed on the Eskom consultancy panel could be considered viable partners in this context. With respect to the above-mentioned question, a series of discussions between McKinsey and the potential BEE partner have been taking place. The result of these discussions is summarized on slides 15 to 23 of the supplementing slide pack and entails answers to all questions raised by ESCOM. We would like to take the opportunity to highlight that regiments will not be our BEE partner, but potentially, and subject to completion of further review, Trillian. In addition to this, the SLA leaves the opportunity to add additional BEE partners and/or change partners. In this case, the same criteria apply. Then you have paragraph 5, which reads the development of ESCOM's top consultants regarding the intended aspirations, roadmap, and key success measures, with a clear goal to minimize the future use of consultants in the organization. The development of ESCOM's top consultant program forms the core and center of the SLA between ESCOM and McKinsey, and in fact, has been the basis for the contract. Therefore, the full details of the process and the achievements has been outlined in the SD&L memorandum that supplements the SLA. In particular, the memorandum outlined the following design criteria. And those are set out, which I will not reach in the interest of time. There is a paragraph which talks about, along the lines of Mr. Singh's letter, about the SLA still being a contract to be signed. So the last page, paragraph in bracket 6, the inclusion into the program of other key focus areas such as contract management and fraud and corruption. There's the conditions of the SLA specifically allow for additional scope to be included in the scope of work and hence can accommodate additional topics like the contract management and fraud and corruption. Specifically on these two topics, McKinsey has already worked on setting up a contract management office to build ESCOM's claims and management capability. This can be easily extended to interface with or include a fraud and corruption capability. We would welcome the opportunity to discuss any of the issues in this note and how we can best serve you on the program further with you. We will aim to update you further on the issues relating to Trillian by 4 March 2016. It would be grateful if you could confirm this will be acceptable. We will naturally keep you appraised of any relevant developments in the meantime. But what we've read there, Chair, relates to the envisaged supply development partner that McKinsey had in mind to subcontract to Mr. Onochi, Mr. Singh. You see that.
I do, Chair.
Here you see that. And I think they too accepted. There was a paragraph I was looking for which also suggests that the proposed agreement to be concluded between ESCOM, sorry, not between you, between ESCOM and McKinsey, was also at the time envisaged that it would be signed. We did read it previously, but I can't find it now, Chair. Anyway, the subsequent letter, there is another letter, the one of the 30th of March, 2016, where you are advised that they will also not subcontract with Trillian in respect of the MSA. You recall that as well?
I do, but if you can refer me to the letter, thank you for refreshing.
That letter Jason.
Mr. Selega, what were the points that you sought to make by reference to these letters? Or was it that even in March, there was still no signed agreement?
Correct, Chair.
Yeah.
Yes, because of the
Okay.
letter of the 30th of
And
March.
are you going to be taking that a step further and saying that it's likely that even in June, no agreement had been signed yet, or you are not going to go that far?
No, I'm going to take it that far, Chair.
Yes, okay.
Because Mr. Singh, when McKinsey is like a creditor, has on his version rendered services to ESCOM. You would understand why they say the agreement was concluded in January 2016, because they want to be paid. They are demanding payment. But when Dr. Wise puts in an affidavit, because now it's a sworn statement, he has to tell the Commission the true facts as to when he signed this agreement. And that's what he says in his affidavit. I don't know whether, because that letter doesn't say we signed the agreement in June 2016. It says the agreement was concluded in January 2016, which you have said, well, you didn't say, but on your version subsequent, that cannot be true, because there was delay from both sides and backdating from both sides.
I guess that, don't forget your point. I guess, Mr. Singh, you must tell me whether you know
Yeah.
from what the date is when ESCOM signed and backdated, and what the date is when McKinsey signed and backdated, if in respect of McKinsey, you're saying it's not October.
Mr. Chair, well, within my personal knowledge, I cannot say that. And hence, the only person that can tell you when he actually signed was Mr. Mamalani.
Yes.
But from where I sit in terms of the documents that I see,
Yes.
I could only envisage that by the 28th of June, based on McKinsey's letter, that an agreement existed and was signed.
So, but are you saying you don't have personal knowledge as to when ESCOM actually signed?
No, sir.
And you don't have personal knowledge as to when McKinsey signed. But based on what you have seen in the documentation, none of them signed in January 2016. And for some time thereafter, nobody had signed. So you say they must both have signed at some stage after January 2016, and they backdated.
That's correct.
As to both, you don't know exactly when, but you say that, well, in regard to ESCOM, Mr. Mabelane must be able to say. But why would you then dispute Dr. Vice's evidence that, look, in the affidavit that I actually signed in October, but the document reflects that I signed in January because I gave that date. But the reason why I did so, because I understood that ESCOM preferred that we should put that date. Why are you disputing that evidence?
Mr. Chair, because as I said, other than for the letter itself, that said we concluded an agreement in January. The
You
letter
don't
goes-
accept now.
Yes.
Yeah.
The letter goes on to rely on the termination clauses that existed within the agreement or the SLA. Now, it is inconceivable that you would send a letter of demand to somebody and not say that it's actually based on an unsigned agreement.
But basically, you are saying you challenge it because of your understanding of the correspondence and other documents and your in terms of logic,
Yeah, and
but
Mr. Chair-
you don't have personal knowledge.
No, I don't have personal.
Yeah, yeah. Okay, all right.
Yes,
Mr.
but,
Slegger.
but Mr. Singh, if the facts are as they are, it would have been ESCOM which should have said, but we have a defense to this claim, to this demand, in the sense that we haven't signed the agreement or sent it to them to sign. They have no leg to stand on. It's you who should raise that as the person to be sued, as opposed to the one who is suing you.
But that is exactly my point, sir. I am saying that by 28 June, when the letter arrives, there had to be a signed contract between McKinsey and ESCOM. Else, why would Mr. Mabalani not raise that defense?
Why would?
Why would Mr. Mabalani not raise exactly the point that you are raising?
So you are saying if to ESCOM's knowledge,
Correct.
when McKinsey sent that letter of the 28th of June,
Yes.
which you said is a letter of demand,
Yes.
if to ESCOM's knowledge no agreement had been signed, one would expect ESCOM to say, but we have no signed agreement.
Exactly.
And you say the fact that they didn't say that suggests to you that there must have been a signed agreement by that date.
That is correct, sir.
That's what you say.
That is what I'm saying.
And that's the basis on which you say by that time, the parties must have signed and backdated.
That is correct.
You no longer say in January there was a conclusion of the agreement. You say it must have been later than that, but not later than 28 June.
That is correct. Mr.
Somewhere in between, both of them must have signed, but they backdated.
That is correct.
That's what you are saying.
That is correct.
Okay, Mr. Slugger.
So just by way of reference, the letter of the 30th of March 2016 is in the same bundle, ESCOM Bundle 14C, page 876.
Page 876.
876, page 876, 877, and here you will see on 877, the penultimate paragraph still refers to a draft of the service level agreement.
You said I must go to page 876.
Yeah.
I am there, but maybe we are at 4:10, maybe we should take a short adjournment. We can take it either now or you can complete the point you wanted to make with reference to this letter.
No, the point is made, Chair,
Yeah.
in what you said to me. I'm just giving you the reference
Oh, okay.
to where you will see even McKinsey says we acknowledge that the draft of the service level agreement between ESCOM and McKinsey entails, even as at 30 March 2016, they refer to it as a draft.
Where are you reading from on page 876?
Okay.
I'm reading from page 876.
No, Chair, sorry. Please turn to 877,
Okay.
the penultimate paragraph. We acknowledge that the draft
Of the services level agreement
Yes.
between ESCOM and McKinsey. entails the requirement of outsourcing a percentage of the total consulting fee to a supplier development partner. We are fully committed to giving effect to this obligation despite the termination. In light of the previously envisaged subcontracting relationship with Trillian, which under the current conditions will not be possible, we would appreciate an opportunity to develop options with ESCOM to ensure that we meet our supplier development obligations. So the 2 points are made in this paragraph. One is there is a draft service level agreement between ESCOM and McKinsey, which means it hasn't been signed as at the end of March 2016, but they say we are fully committed to giving effect to this obligation despite the termination. The termination that they are talking about there is obviously earlier than the termination that is contained in the letter of 16 June 2016. So which termination are they talking about there?
Is it in the same paragraph, Chair?
Yes, same paragraph. After the first sentence, the second sentence says we are fully committed
Oh
to
no.
giving effect to this obligation despite the termination.
Oh, yes. Okay, I see. No, that's the termination of McKinsey's further discussions with Trillian for Trillian to become their subcontractor.
Oh, the termination of those discussions.
Yes.
Okay, all right.
So then they decide here that Trillian will not be McKinsey's supplier development partner.
So I guess is the point you are making that as we look at when it is that the agreement was signed, we must accept that as at 30 March 2016, it had not been signed. Otherwise, they would not talk in these terms. That's the point
Correct.
you were making.
Correct.
Okay. You accept that point, Mr. Singh?
That is correct.
You accept it? Yeah.
Yes.
Okay, all right. Was there another point in regard to this letter that you were making other than that?
No,
No.
I think I wanted to follow up on that
Follow up.
demand.
Follow
Can
up.
I follow up on
Yeah,
that demand?
yeah.
Mr. Singh, you see, it seems on the documentation that the payment or the decision to make a payment to McKinsey came from ESCOM. And McKinsey only reacted pursuant to the letter of termination. And I would like you to quickly, before we take the adjournment, to turn to the same bundle, page 829.19, which is a submission to the BTC. ESCOM bundle 14C, 829.19.
I've got it. It's dated 9 June 2016.
Thank you, Chair.
8 to 9 point?
829.19.
829.19.
It's a submission document from ESCOM to the Board Tender Committee, and it's dated 9 June 2016.
Yeah. So that's before McKinsey's letter of demand. And the resolution required is, it is resolved that the BTC grant approval to cancel McKinsey risk-based process. 2.1, allow...
Well, before you deal with that, Mr. Selega, let's just, for the sake of completeness, say who signed the submission.
Yes.
It's not clear who compiled it, but on page 829.22,
Yes.
it says supported by Prish Govender, Program Director, and he has signed on 6 June 2016 And then below that says approved by Edwin Mabelane, Chief Procurement Officer, and he has signed, and that's on the same date. And then you can tell us what it says.
Yes, thank you, Chairman. Mr. Singh, would you have had sight of this before?
Let's say the title of the submission is given as Briefing on McKinsey Risk-Based Contract.
Yes.
And that is under 1. Under 2, it says resolution required. And it says it is resolved that the BTC grant 2.1 approval to cancel McKinsey risk-based process. 2.2 allow all costs to be negotiated and finalized to be approved by the relevant tender committee. 2.3 approval of activities to be redirected to existing contracts where appropriate, with the incorporation of similar SDL objectives and the option of contracting on risk-based approach. Okay, you
Yes.
can continue.
So there, in this submission, Mr. Singh, to the BTC, it appears that the willingness to make a payment, negotiate and finalize on costs, came from the part of ESCOM. Even before the letter of demand, even before the purported termination of the MSA or SLA. Your comment?
Mr. Chair, I think the
I'm
first
sorry, would
question-
you just repeat? I'm sorry, I was looking at something that I
Okay.
raised just now.
So it appears from this document, the submission to the BTC, that the willingness to make a payment under the MSA, even before it is terminated, purportedly terminated, even before the letter of demand you have referred to of McKinsey, that ESCOM was willing to negotiate and finalize on the costs with McKinsey.
Yes, you may comment,
Your
Mr.
comment.
Singh.
Mr. Chair, I think the first question that Mr. Seleka asked was, would you have had sight of this document? Mr. Chair, I wouldn't have had sight of this document as I did not
Yes.
sign it. But the nexus of this document, so the origins of this document, originates from a steering committee meeting. Was it the second or the third steering? At one of the steering committee meetings, there was a closed session where there was a discussion held, and I think it was, either the June meeting, I think it was a June meeting. But anyway, there was a steering committee meeting where we held a closed session to decide on the future of the MSA. And at that meeting, the SteerCo resolved that it would probably be best, for the reasons discussed at the SteerCo, that it would recommend to the BTC to consider cancelling the MSA for the reasons that it had discussed, as well as the reasons that are set out by Mr. Mabelane and Mr. Govender in this submission. So that is the nexus behind this document, Mr. Chair. In that meeting, Mr. Chair, I also requested, given the fact that the SteerCo had come to the conclusion that there would need to be a termination of the MSA, I requested that Mr. Mabelane and Mr. Govender consult legal as well as commercial. Now, commercial was another word for procurement with an ESCOM, to understand the consequences of the said termination. And once they were satisfied with that, they would proceed to the BTC to, at that stage, get the required approval or submit a recommendation to get an approval as to what they had thought would be appropriate in the circumstances. So that is the background behind it. So, Mr. Chair, in terms of responding to Mr. Seleka's comment directly, no, I would have not had sight of this specific document, but I would have known of it because of the SteerCo. Secondly, Mr. Chair, I am not too sure how Mr. Seleka comes to the conclusion that ESCOM had mooted costs before the termination of the SLA, because the termination is contemplated in the document. So they would have taken a decision to terminate if they thought it appropriate. And if so, I would assume that Mr. Mawalani had gotten advice to understand whether there was cost implications relating to termination. And again, Mr. Chair, if there was a signed contract between McKinsey and ESCOM at the time, the termination clauses of that contract would result in these costs that are requested. So, as it relates to ESCOM being willing to pay, again, it would rely and relate to the contractual agreement between ESCOM and McKinsey at the time.
Well, I see that in this document, at the first page of this document,
Yes.
in bullets or under bullet point, second bullet point, it is said the contract was signed in January 2016. Before that, it says a letter of acceptance was issued to McKinsey in December 2015, allowing work to commence until the contract was fully developed and finalized for signature. And then it says the contract was signed in January 2016. And then next bullet point, ESCOM submitted a letter to McKinsey on 19 February following a program kickoff steer committee wherein key concerns on the program mechanics were raised. In June 2019, a document signed by, among others, Mr. Prish, signed by Mr. Prish Govender and Mr. Edwin Mabelane, signed on the 6th of June, 2016, says that the contract between ESCOM and McKinsey was signed in January 2016. The confusion doesn't stop.
Evidently, Mr. Chair.
Yeah. Okay. Let's take the short adjournment. It will be 10 minutes. We adjourn. Okay, let's continue.
Thank you, Chairperson. Chair, we will ask Mr. Singh about allegations made by the travel agent in due
By?
course. By the travel agents in due course.
Yes.
But Mr. Singh has indicated in an affidavit, the supplementary affidavit, that he wishes first to have, for his team, legal team, to engage with the legal team for Mr. Essa before he responds to those allegations. But we have agreed that he could deal with some of the aspects relevant to or arising from that affidavit.
Well, if he is still going to respond, I was hoping that if we didn't finish Mr. Singh's evidence today, we'd finish it tomorrow.
Yes.
I know he's due to come back on Transnet later in the month. So, how far is that process?
Chairperson, I think maybe it's also prudent to place on record that we were also over the weekend served with additional documents, etc.
Yeah.
And based on that, I've informed my learned friend, I don't want to go into the details, is that we most probably going to do another affidavit to deal inter alia with some of the issues that's now been raised in respect of McKinsey and the witnesses, which would most probably make incriminating statements with reference to people. So time will be needed to actually serve it on the relevant persons.
Yes.
Even if we come to the end of Mr. Seleka's examination by tomorrow, we can't take it further.
Yeah.
We have, however, when it comes to the issue of the travel agents, agreed Mr. Seleka can ask him about the various invoices. So
Okay.
what my client has done, he's gone and he's analyzed it and he's drafted a little spreadsheet to be able to deal with
Yes.
those issues. So he can, to that extent,
Yes.
he feels comfortable enough to, with reliance on this, deal with the various invoices, etc.
Oh, okay, okay.
And that we think would also assist in speeding things along
Yeah.
at this stage.
No, that's fine. I guess what I'm looking for is that there ought to be an understanding of when the process of obtaining, of preparing his further affidavit will be completed, or when the affidavit would be ready. Obviously, if it's got to be served by way of Rule 3.3 on certain people who may be implicated in it, that would have to be done. So maybe at some stage, either at the end of today's proceedings or tomorrow, let's try and have finality on the dates. But if Mr. Singh is able to deal with some of the issues connected with that, then whatever can be done should be done in terms of covering as many issues as possible. And those that he might not yet be able to deal with until he has done the affidavit, then he would deal with them. Then hopefully, if we have to make time for him at some stage after tomorrow, then the time would be limited just to cover the specific issues.
Chairperson, it would even go a little bit further in lieu of spending a lot of time on re-examining.
Yes,
We will
yes.
take care of those
Yeah,
issues and literally
yes.
just highlight it
Yes,
under
yes.
oath, say we refer to
Yeah.
this issue. And I think that would save a lot of time because
Yeah.
I think you can see there's going to be a number of issues to be
Yeah.
dealt with in re-examination.
No, that's fine.
Thank
That's fine. Okay, Mr. Slater.
Thank you, Chair. Chairperson, before I proceed, During the adjournment, my learned friends made a request to me in regard to that letter of the 28th of June 2016, which is in ESCOM Bundle 14 bracket C, page 743. The request, which I'm not going to do, I told them, is
Which
that
you are not going to?
I'm not going to do what they are asking me to do.
Oh, okay, yeah.
But I need to place it on record
Yeah.
what they are asking to
Yeah.
be done, is to have the letter, the bullet points in that letter read to the record, because they are, the letter seeks to quote clauses of the contract and reproduce them in this letter. And they wanted me to give Mr. Singh the opportunity to comment on that.
Well, he could comment even if they are not read into the record, if that was necessary.
Yeah.
Is what you were not inclined to do, the reading into the record or allowing Mr. Singh to comment on
Not the former.
Yeah,
reading into
yeah.
the record.
Yes.
Because,
Okay, yeah.
yeah, because the question is, where would Dr. Weiss and Mr. Vikas Sagar have obtained these clauses if he says in his affidavit that the contract was only sent to him in late September, early October 2016?
Don't you want to ask Mr. Singh to comment on those parts without reading them into the record? And then if you want to question him on his comments, then you do that.
Yeah.
Okay?
Yes, Mr. Singh, you have referred the chairperson to that letter, the letter from McKinsey, which is a letter essentially of demand. And I suppose you know what your legal representatives wish to have done. Are you able to comment on the clauses that are quoted in that letter?
Yes, Mr. Chair. The clauses as quoted in the letter refer to clause 24.14 of the SLA, 13.1 of the SLA, 7.3, 7.31, 7.32, 7.33, 7.35, 7.33 again, 7.34, 7.35, and 7.6 lastly. Mr. The point again is, as Mr. Sedek has raised, that these clauses come verbatim from the service level agreement that we have said has been signed. So the issue is, if Mr. Weiss only received a copy of this agreement in October, as he alleges, where did these clauses actually emanate from?
Yes. I'm just going to 7.4.3. Now, this is the letter which says the master service agreement was finally concluded in January 2016,
That is correct.
which you dispute, which you challenge.
No, Mr. Chair, what we're challenging is when this agreement was actually signed.
Yes, but when we say conclude, we talk about signing. You and I understand that we are on the same page on that.
Mr. Chair, as I tried to explain to you before, in the contract contained 2 suspensive clauses,
Yeah,
and those suspensive clauses needed to have been fulfilled by the 31st of January. And ESCOM's, well, our version is that those conditions were fulfilled, and therefore, the contract was concluded.
well, remember when we were talking earlier about whether the agreement was concluded in January or later, we were talking about when it was signed. and and you said at a certain stage, nobody signed the agreement in January, as far as you are concerned. Everybody signed it later, but backdated it.
Okay, if you define concluded as the date of signature?
Yeah,
then
that's
we-
yeah,
then we-
yeah.
yes.
Because if it's meant to be signed, until both sides have signed, it's not concluded. Okay, you accept that. An agreement that requires to be signed is not concluded until both sides have signed.
Well, Mr. Chair, it's fine if we, if we go
Okay,
there.
okay, all right. But you and I agreed earlier, I thought, that if we find a time in 2016 when the parties had not signed the agreement, then there was no agreement between the parties yet. I leave out the issue of the offer and acceptance, which we discussed earlier. But I thought that we understood each other, that as long as ESCOM had not signed, McKinsey had not signed, there was no agreement yet. Did
Mr.
I
Chair,
misunderstand?
well, Mr. Chair, if we look at it, right, legally, there was an obligation through the letter of award.
Letter?
Through the letter of award,
Yeah.
there was a binding
Yeah.
agreement between ESCOM and.
Yes, but remember, I said, let's leave that
So
out
park
for the
that,
time
agree.
being.
I park
Yes,
that, right.
and the letter and offer and acceptance.
Offer and accept.
Yeah,
Flowing therefrom is the service level agreement.
yes,
Now, the service level agreement itself has two suspensive conditions for it to become effective.
yes. That I understand. You have explained that. I
Yeah, so
understand that.
from what I understand is, if the suspensive conditions are fulfilled, the contract becomes effective, notwithstanding when it is signed.
Yes, but when you say that, you are relying on the offer and acceptance, isn't it?
No, even the agreement itself, Mr. Chair.
Well, if
Unless-
it hasn't been
unless-
signed, if it hasn't been signed, how can
Unless
it
there's an
be?
express clause in the agreement that says, this agreement only becomes effective on date of signature.
No. Remember, we are talking about an agreement here, which we both understood or understand to have required both parties to sign.
Yes,
That's why they signed, and that's why they even backdated, because it was important that it be seen to have existed from a certain date.
Okay,
Or am I confusing you?
I think you are, Mr. Chair.
Okay, all right. Let's take it. Let's take it step by step. Do you accept that there was no service level agreement or MSA before both ESCOM and McKinsey signed?
Mr. Chair, no, because in my.
You say it was there.
When the suspensive conditions were fulfilled.
Yes.
Mr. Chair, the agreement
Yes.
became effective.
Yes,
And Dr. Weiss even agrees
yes.
that it became effective, or there was a desire to backdate the agreement to the date on which it became effective,
So,
which is sometime in January.
So is your position that even in February, remember you have your letter to McKinsey dated 19 February
Yes,
talking about signing that was still to happen of
Yes,
the
Mr.
contract?
yes, Mr.
Are you saying even on the 19th of February, as far as you are concerned, if the two suspensive conditions had been met already, and I can't remember whether they had been met, if they had been met, then as far as you are concerned, there was a master service agreement between McKinsey and ESCOM as at that date?
Was effective.
It was there,
Yes,
and it was binding.
yes, sir.
And so you say the signing was neither here nor there?
It was good for governance purposes to have it signed.
But it was not important.
It was not important.
Yes. So when the termination happened, you remember you said earlier on, they must have signed by the 28th of June,
Yes, sir.
because otherwise, if anyone or if ESCOM talked about termination, McKinsey should have said, termination of what? Because we haven't even signed.
Agreed. Or when the letter of demand came,
Yes,
ESCOM should have
but-
said, but why are you issuing a letter of demand?
But then, if signing was not important, then it would not have been open to ESCOM to say, what are we talking about? Because we haven't signed. Because the answer would be, we don't have to sign, we already have the agreement on your version.
Yes, Mr. Chair, I think maybe when I said signing is not important, it's probably tongue-in-cheek, but there is a requirement for contracts to be signed with an ESCOM.
Mr. Singh, it was not in tongue-in-cheek.
No, Mr. Chair, okay. Seriously, I think there was a requirement for the contract to be signed in terms of, if you look at the 1034 document as well,
Yes.
there is a requirement for the contract to be
Yes.
signed.
So, but once you accept that, then you have got to change your earlier evidence that there was a master services level agreement even before the parties signed. Once you say that it was a requirement to sign, and at a time when that requirement had not been met, there couldn't be a master service agreement between the parties.
Well, Mr. Chair, my understanding is that if the conditions of a contract, the suspensive conditions of the contract are fulfilled, the contract becomes effective on the date on which it's fulfilled.
Yes, leave out the suspensive conditions because we have talked about it. Just talking about signing.
Okay, if there was no suspensive conditions and there was no other agreement between the parties to say, listen, this thing is effective, other than the fact that we haven't signed, then signature is required.
Well, you just said to me a while ago that when you said signing was not important, that was tongue-in-cheek. Okay? And you said seriously, signing was a requirement. Remember that? And in response to that, I said to you, but if signing was important, was a requirement, then you can't say that there was a master services agreement between the parties at a time when they had not signed. In other words, when they had not met that requirement.
But Mr. Chair, again, I think we're talking about a hypothetical.
No. Before we get there, remember that there is an issue here.
Yes, sir.
That Mr. Dr. Weiss says, in effect, in his affidavit, in June, the McKinsey had not signed the agreement. I'm saying in June, but for many months before October, there was no agreement because McKinsey had not signed. And he says he signed in October, but backdated his signature to January. So the question of when it was that there was an agreement between the two parties is important because whatever payment gets made, we want to find out, was it made at a time when there was an agreement and what was the effect of the agreement? So we have letters that say the agreement was concluded in January, but you have said, no, it can't be. So, but on what I understand you to be saying now, you accept that, one, the signing by the parties of the agreement was a requirement here, and you accept that if we find at any time that they had not signed, we can accept that, therefore, at that time, there could not have been a master services agreement between the parties.
Mr. Chair, I still don't see how the suspensive conditions are not relevant in that example.
Sorry, just repeat that.
I say, Mr. Chair, what I find difficult in agreeing to your last proposition is in the absence of the fulfillment of the suspensive conditions.
No, what I'm saying is, I'm not dealing with the question of the fulfillment of the suspensive condition now. But I'm simply saying, assume that the conditions, the suspensive conditions were met.
Yes, sir.
If the agreement had not been signed, and you say the signing was a requirement, I'm expecting that you will accept that as long as the agreement was not signed, we can't say there was a master service agreement between the parties, because you say signing was a requirement in this case.
Okay, let's maybe answer the question differently.
Yes.
So let's agree that on your version, not
My version.
on your proposition,
Proposition,
on
yeah.
your proposition, sir,
Yeah.
that there would be no agreement with no signature. That's your proposition.
Yeah, you say if there is no signature,
Then there's no SLA.
agreement.
There's no
That
SLA.
that is what you said, yeah.
So all I'm distinguishing, sir, is I'm saying there might be no signature, and therefore there is no agreement
Yes.
as you proposed it.
Yeah.
But I'm taking that one step further to say, by virtue of the fact that there was no signature, it does not mean that there is no liability.
Yeah, well, you're introducing liability now. We talk about whether there is an agreement or there is no agreement
Because
when there
Mr.
is no
Chair,
signature.
you prefaced this by saying that the signature is important to understand whether the payments were made in terms of an existing liability.
No, I said in terms of an existing agreement.
But that's the point,
Yeah.
Mr. Chair. Where does the liability come from?
You see, if you talk about liability, you might talk about liability that comes from the contract. You might talk about liability that comes from something else. Okay? So that's why I'm just saying, let's talk about the contract. But my understanding of where you are now on your evidence is that you are saying, in this case, the signing of the agreements by both parties was a requirement, and as long as they had not signed, one can't say there was an agreement. But it's a different situation where the signing is not a requirement. I'm now going back to something you said earlier, as I understood it. That's where I understand you to be. Is it not what you intend conveying?
Okay, Mr. Chair, let's just put it this way. For ease of reference, my version is a signed version of this contract existed
Yeah,
sometime between March and June,
yeah,
based on the evidence that I've seen.
yeah. Okay.
So that puts-
You're going back to the facts.
Yes.
So, or to the version that you put. I'm saying
Yes.
not necessarily to the facts, because we are trying to establish when both
contract
parties
was signed,
signed.
yes.
But I've told you what I make of your evidence now, Mr. Selega.
Yeah, no. Thank you, Chair, because Mr. Singh, your letter of the 19th of February would not have been drafted the way it was drafted if you believed that the fulfillment of the suspensive conditions brought about the existence of the agreement.
Mr. Chair, again, we go back to this issue of whether there was an agreement. The parties, for all intents and purposes, if the parties did not believe that there was an agreement and the suspensive conditions were fulfilled, there would have been no need for a steer code. There would have been no need to mobilize the people.
No, I'm talking about you, Mr. Singh. You wrote a letter on the 19th of February, 2016, and you said the signing of the proposed agreement, not the coming into effect. You specifically say the signing is contingent upon the receipt of satisfactory responses to the above requests. You were
Yes,
very
Mr.
specific.
Of the proposed agreement, I did not say of the fact that we did not have how can I say, an effective contract, because the parties behaved as if there was an agreement in place.
As if.
Yes, there was only the mere fact of actually the physical signature of the contract. And that was the only thing that was outstanding, and therefore we refer to a draft contract. It does not say, if that was the case, Mr. Chair, the letter would have been drafted very different.
Well, I'm not sure what the answer, what the effect of the answer that you're giving to Mr. Snega is. But I just remain on what I think has come out clearly from your evidence, namely the signing of this agreement by the parties was a requirement in this case. Therefore, if the parties, if we talk about any time in 2016 when factually the parties had not signed, we can't say, as at that time, there was a master services agreement between ESCOM and McKinsey. So that's the one set. You have said something about the suspensive conditions. For now, for my purpose, in terms of what I've been asking you, for me, that's neither here nor there for present purposes. You know, what was important is to establish what your understanding was. So that's where I am.
Yes. Thank you, Chair. I mean, the letter is what it is the signing of the proposed contract. Is contingent, or if you want to use a simple word, is dependent upon the receipt of satisfactory responses to the above request. It is a proposed. But I'm going to leave it there, Mr. Singh. If you want to comment, you may comment. But I'm going to leave it there.
I think he has said enough.
You've already said to the chairperson. Yeah.
I don't think he wants to say anything further.
Yeah.
Yeah.
But based on this letter, Mr. Singh, and you were expecting a response, I suppose, from McKinsey, is it not fair to say it would be expected of you to know when exactly was the SLA signed?
Mr. Chair, I think we've also traversed this issue the previous time that we gave testimony. The delegated authority relating to signing of the contract.
Was it not in relation to the corporate plan?
No,
Mr. Chair. It was in regard to this one.
No, it was with regarding this one.
Okay, okay.
And eventually was signed by Mr. Mabalani. And as I mentioned before, that the second steer code did indicate that the contract was going to be signed by the 31st of March. So for all intents and purposes, I was under the impression that the agreement was signed by the 31st of March. And if you look at current evidence in terms of, we go back to letter 743, for example. Mr. Chair, again, it would be rather, how can I say, bizarre for McKinsey to send a letter of demand, as the letter of 28 June 2016 is. And let's say we disputed, ESCOM disputed the fact that a contract existed. And we went into a court process. So we would either have produced a document that does not exist or was not signed as of this date and embarrassed McKinsey because they are claiming that there is this contract that exists, yet we prove that it does not exist. And I don't think McKinsey would have taken a reputational risk such as that to issue a letter of demand knowing that a service level agreement is not signed?
No, you see, Mr. Singh, I don't have any difficulty with that point you made. Namely, one would expect that McKinsey would not issue a letter of demand based on an agreement that had not been signed. I don't have a difficulty with that point in principle. Obviously, Mr. Seleka can canvass issues further around that, but I don't have a difficulty. That's what one would expect. Equally, I think, as Mr. Seleka said earlier on, one would have expected ESCOM, upon receiving that letter of demand, which was based on an agreement, to have taken the point or taken the position that, but we don't have an agreement with you. If the position was that there was no agreement.
Exactly.
I don't have a difficulty with that, you know. But it makes it all the more important to establish as to exactly what the position is, because Dr. Weiss has said, I signed this agreement in October and backdated it. Now, when you look at that, it wasn't to Mackenzie's benefit or advantage for Dr. Weiss to disclose that he signed it in October and backdated it. It doesn't help them to explain that. But if it is the truth, it is the truth. If, as far as they are concerned, it is the truth. As Mr. Seleka was saying, maybe Dr. Weiss said, well, it's a fact. That is what happened. So you ask yourself, why would Dr. Weiss have said he signed the agreement in October and backdated it to January if he actually signed it earlier? Because actually a version that showed that he signed it earlier may have put them in a better light than saying we signed in October and backdated it to January. You see what I'm talking about? It may well be that you might say, or somebody else might say, no, Chair, there's something that you have missed. This is how it would help them to say it was signed in October instead of admitting that it was signed during the first 6 months of 2016. But then if there is such a thing, somebody must tell me.
Well, Mr. Chair, I'll attempt to tell. Mr. Chair, McKinsey has gone on record on a number of times at the parliamentary inquiry, making announcements on their own relating to the billion or so that they paid back, have gone through an extensive exercise on their own version, looking at thousands of records, emails, and investigating I don't know how many of their own employees. Through that entire process, no one actually discloses that this agreement did not exist. Yet, in December 2020, Dr. Weiss decides to say that this agreement did not exist. So, during that entire process and that entire investigation, what was Dr. Weiss's view and what was McKinsey's view? During that entire process. It was not a trivial process if you understand how and what they did. In the ESCOM application, Mr. Chair, itself, they do not rely on the fact that an agreement did not exist to repay the money. They they go through this entire process of saying now they understand that ESCOM misled them, relating to the fact that the National Treasury approval was not forthcoming. Even on that version, they don't say that, listen, it would have been very easy for them to say, well, you know what, we made a mistake, there was no agreement, and therefore we are repaying the money. Which would have been an easier way to explain the reason as to why they're repaying the money.
But do you not accept that in all of these circumstances, they would not have sought to advantage themselves in any way by saying they signed the letter in October, if in fact they signed it much earlier?
Well, Mr. Chair, if that is the case, I come back to my original point that I made this morning, is if that is the case, then the 28th of June letter is either made in bad faith or is fraudulent.
But-
Because the truth of the matter is, Mr. Chair, ESCOM relied on this document.
No, but that's fine. Remember, my question is, do you accept or do you not that, I mean, normally, from what you have said, I think you are suggesting that Dr. Weiss is being untruthful in saying that he signed the agreement in October. He must have signed it during the first half of 2016. So my question is whether you do not accept that he or McKinsey would not derive any benefit from saying he signed the document, the agreement. No, what benefit do they get by saying that?
Mr. Chair, if you didn't have regard for all of the facts that we now know around the issue of my letters referring to a draft contract, for example, and all of that, and you just had these letters that came from McKinsey, what would your view be? Your view would be there's an agreement that's in place, there's a
No.
termination clauses that are relevant to this, let us engage.
No, you are dealing with a different point, and I know the point you are dealing with because you have told me about it, and I've indicated to you that I understand that point. I'm simply saying, if McKinsey actually signed the agreement during the first 6 months of 2016,
Yes.
it doesn't appear that there would be any benefit for them if they said instead, untruthfully, they signed it in October. Normally people become, tell untruths when they seek to protect themselves or to gain benefit. So I'm saying that for them to be paid, it would be in their interest actually to say we actually signed in January. So as we were doing work, there was an agreement in place. Rather than effectively disclose that there was no agreement until October, and then we backdated it. So as we were doing work for ESCOM, we had no agreement with ESCOM. That was not beneficial to them to disclose that.
Well, Mr. Chair, I can then only assume that the positions that Dr. Weiss and Mr. Sega took in the 28th of June letter, they took in the interest of McKinsey.
You see, I've said to you, I understand your point about that.
Yes.
And about saying, but the letter talks about the agreement having been concluded already. Of course, it says January, but it talks about it having been concluded. That might need explanation from their side, from Dr. Vice's side, and so on and so on. I understand that part. But I was saying, let's look at that part of the evidence that was simply to the effect that they signed in October, but they backdated. If we look at that.
No, I was trying to explain that.
Yeah.
So in my view, the only way I could explain this dichotomy, Mr. Chair, is if, as I said, Dr. Vice and Mr. Sega acted, let's call it, in their professional capacity in issuing this letter. And in December, when Dr. Vice gave the affidavit, he probably gave it in his personal capacity and wanted to, I don't know, disclose that, okay, this is the actual truth that existed at the time. But in the capacity of a partner of McKinsey, this is what I had to do. That's the only explanation I can afford to use.
I guess we have canvassed it sufficiently, Mr. Selega.
I'm not going into it. Chair.
Yeah.
My question was about Mr. Singh's knowledge as to, well, that wouldn't it be fair based on his letter of the 19th to expect that he would know when is the MSA signed? Because there you say the signing of this proposed contract is contingent upon you coming back to me on these points. Your answer was you assumed that it was signed the 31st of March 2016.
No, Mr. Chair, I said it would be incumbent upon Mr. Mabalani to ensure that the agreement was signed, in that he was the delegated authority to sign it.
Oh,
My expectation would have been, it would have been signed by the 31st of March, given the presentation that was done.
yeah. But
But
I hope,
maybe just don't forget your point, Mr.
Okay.
Selega. The issues that you set out in your letter, in respect of which you said the signing was contingent upon those issues being satisfied. To your knowledge, were they satisfied, all of them, and if so, when?
Mr. Chair, I think the STEARCO minutes does go to some extent to indicate that we were not completely satisfied
Yes.
with the responses that
Yes.
McKinsey had given.
Yeah.
But in principle, if you look at the letter that McKinsey's response was, they accepted each of the issues that were raised in terms of, how can I call it? Let's say, for example, change management. They accepted that change management should form part of the master services or the top engineering program. Fraud and corruption, for example. Contract management will form part of it. So each of the issues that we raised, in principle, they did not reject it. Right? So basically, I think the actual ironing out of how it would form part of the actual underlying master services agreement was the issue that was outstanding, and that is recorded in the minutes of this hearing.
But up to when was it outstanding? Because based on what you say in your letter, as conveyed by Mr. Selega, because I'm relying on what you just said now, there would be no signing until those issues those requirements were sorted out. So until when did it remain outstanding?
Mr.
That
Chair,
issue,
I am not too sure
to your knowledge?
what the date of that STEARCO was where we recorded that.
The date of?
The date of the STEARCO
Yeah,
that recorded the fact that McKinsey had responded,
yes.
yet we were not completely satisfied with the
Yes.
response.
Okay.
So
But would it be correct to say you have no personal knowledge of whether or not that outstanding issue was ultimately satisfied?
I would not, Mr. Chair, because Mr. Mabalani, I don't recall that Mr. Mabalani had come and engaged
Yes.
with me
Yes.
regarding this letter
Yes.
and the contents thereof.
Yeah. So Mr. Mabalani might be the person who can clarify.
Who can clarify? From what I can understand, Mr. Chair, I think there was some discussion at one of the steercos to say, listen, that we did send this letter, they did respond, and there are some issues relating to the response. But we never then said that it should not, the contract shouldn't be signed or anything like that. It might have been one of the reasons that was mooted around the ultimate termination of the agreement at some point. But I was not, I have no personal knowledge and relating to Mr. Mabalani coming to me and saying, listen, we sent this letter, this was the response, can I not sign?
Okay. Now, that, of course, what you have just said now, and the contents of your letter, insofar as it said, the signing can only take place after you have satisfied these requirements.
Yes, sir.
Depending on what the evidence is as to whether all of those issues were addressed or those requirements were satisfied, it may well be that as long as one of them was not satisfied, no signing took place, which may explain why the signing might have taken place in October on the part of McKinsey, because there was this issue that remained unsatisfied. But it depends on whether there's somebody who can come and say, yes, it was satisfied, or no, it wasn't satisfied, because if there was a signing of the agreement without those issues having been satisfied, that would be contrary to your letter.
I agree, Mr. Chair. But if that was the case, Mr. Chair, when Dr. Weiss was presented with the document for signature, he would have then raised it. If that was the reason why they had not signed by then.
I'm sorry, just repeat the earlier sentence.
I'm saying, on your proposition, Mr. Chair, of, let's call it these issues, being the reason for non-signature or delays in the signature, I would then have expected Dr. Weiss to be aware that this was the reasons, and then once he was confronted with the document for signature, he would have said, but we can't, because Mr. Singh still needs to be satisfied, which is not what he said.
Of course, that is if they were still not satisfied, those issues. If by October, when he signed, they had all been satisfied, then he wouldn't have to raise any issue.
Well, Mr. Chair, if there was this delay,
Yeah,
then I would assume so. And
Yeah.
if it was for the reasons
Yeah.
that
Yeah.
you asserted.
okay. Mr. Silega?
But, Mr. Singh, if you wanted these aspects to be satisfied, you, ESCOM, it would be you, ESCOM, if they are not met and satisfied, that you would not sign the contract. I mean, McKinsey stands to benefit. It can ignore this thing and sign the contract, render services, and get paid.
No, Mr.
But it is to your benefit because the demand or the request for these conditions or these aspects to be met, it comes from you.
I agree, Mr. Chair.
And I want to deal with one of them, but let me give you a chance to just address the chairperson. What do you say to that?
Well, he says he agrees.
Okay,
I agree.
yeah.
Yeah.
And one of them, it seems, was never fulfilled, which is the development of a BEE partner, bracket, Regiment's Group, close bracket, as regards the vision, aspirations, skills, and competency mix and overall plan for success over the contract duration, including a focus on the health of the relationship with McKinsey. They told you in the letter of 25, we are not taking Regiment as a partner, but we are contemplating taking Trillion, but subject to the due diligence. And then on the letter of the 30th, they said, we are not taking even Trillion because they failed our due diligence process. That condition was never fulfilled.
I agree.
Yeah.
In which case, then Have you got any reason why ESCOM would have signed the agreement with the McKinsey, even if one of those requirements specified in your letter, including that one, was not satisfied?
Well, Mr. Chair, as I said, I have no personal knowledge as to when this document was signed and under what conditions it was or it was not signed. All I can say is factually, yes, I did sign the letter. Yes, it had a condition in it. But if you look at the specific condition that Mr. Seleka refers to, in their letter, they do say, as he said, that the relationship is under review, and the annexure to the SLA allows for multiple or additional, how can you call it, SDNR partners to be considered. That's the first point. Second point is, when they did inform us that it was not going to be Trillium, they came with other options in terms of an SDRN partner. So it was not on the basis that because that thing was not fulfilled, that there would be no agreement. Because they came with other options, right? According to Dr. Weiss, I think, they came with the proposals right up to September, I think. August or September, with proposals.
But what do you say to this proposition that, or let me put it this way, is the position not that you, as Mr. Singh, as the author of that letter of 19 February 2016, you would have been surprised if ESCOM or Mr. Mabelane signed the agreement, even if one of those requirements, such as the one that Mr. Seleka has met, had not been satisfied?
Mr. Chair, ordinarily, I would probably be surprised.
Yes.
If in the absence of the steer code.
Yeah.
So the letter of the 19th was issued, McKinsey responded, then there were subsequent steer codes. Now, the letters were, as I said, or the responses were discussed in this, and the steer code took certain positions. So, as I said, ordinarily, if I had issued a letter, and if I was dealing directly, then I would expect a response, and I would be the one that decides and makes a decision. But in this case, Mr. Chair, there was the steer code. There was additional information that was discussed in the steer code. And then there was Mr. Mabelane that decided to sign or not sign. And in my view, given the context of the discussions in the steer code, Mr. Mabelane must have signed or decided to sign. With whatever date, I'm not too sure. But I don't recall Mr. Mabelane expressly coming to me and saying, listen, these 5 things are a problem for you. Must I or must I not sign? So that did not happen.
Yes, but
Well, let's say what did not happen, I don't recall it happened.
yes, you would have, you expected him to come to you and deal with that question if there was one or more of the requirements that had not been met. Is that right?
No, Mr. Chair, I'm saying.
I accept that you say you can't recall whether.
No, I
it came.
agree. What I'm trying to convey is that in the absence of the steer code, where these things were then canvassed, that allowed Mr. Mabelane to understand what was happening. I wouldn't have expected him to sign without engaging,
Yes.
because he would have not known.
With or without as you say, SIECO or whatever.
No, I'm saying, in the absence of a steer code,
Yeah.
I
You
would expect him to come
back
to me and say, listen, we've issued this thing, can't I sign?
Okay. Okay.
But because the steer code was in operation, and these issues were discussed at the steer code, and Mr. Mabelane was part of the steer code, we would have either discussed them and decided on them, and that would have formed Mr. Mabelane's mindset at the time regarding whether he could or couldn't sign
Without coming back.
without coming back.
Yeah. Okay, but you have no personal knowledge of,
I don't
One?
recall. I don't recall. Mr. Chair.
you have no knowledge whether he signed with them having been satisfied, all of them, or without one of them, or maybe more being satisfied? Or is the position that you accept that one or more of the requirements set out in your letter was not satisfied, but there may have been a reason that persuaded Mr. Mebalane to sign, even if that one was not satisfied because of the discussions that happened at Sieko?
Mr. Chair, I think it's the latter proposition.
Yeah.
Yes.
Okay. Mr. Selega.
Yeah. Thank you, Chair. Mr. Singh, I'm sure Mr. Mabelani is going to refer us to you as to whether or not these requirements were met, because you wrote the letter, they wrote it back to you. You need to tell us what you know, because you communicated directly to McKinsey and not Mr.
Well,
Mabelani.
I thought he accepts that he has he's not in a position to say they were all
Okay.
met. Am I right?
Well, Mr. Chair, let's put it this way. If you have a reading of the letter, the response, there are no issues. McKinsey does not take issue with any of the requests. Okay? So, on face value, all the requirements were met. Okay? When we go into Steerco, there is one of the Steerco minutes that reflect that we do not believe that McKinsey has addressed all of the issues holistically. So I think that's something, there's some minutes to that
Yeah.
effect. But if you had to go and read the letter, all of the requirements were met. So they have not.
No, you can't answer the question like that, Mr. Singh. Well, there is the question of what your personal knowledge is, okay?
Okay.
Whether they were all met or they were not all met. And then there is a question of what your source of knowledge is, okay? If you say, I'm only relying on this document and this document, and I interpret it to say they were all met, that's one thing. But you might say, I do know that irrespective of this document, they were all met. I understand you to be saying, I don't understand you to be saying that from your own personal knowledge, you know that they were met.
No, Mr. Chair, I mean, the letter is addressed to me. So this letter.
Leave out the letter for now. In terms of just knowing what happened, do you have knowledge whether all those requirements were met? And then you can go to the letter in terms of what was happening, where you sufficiently involved to have had personal knowledge whether they were met.
That's what I was getting to, Mr. Chair. I mean,
Yeah, okay, all right.
the letter that was signed by me, obviously
Yeah.
I have personal knowledge of that.
Yes.
And then the response would have come to me
yes.
in terms of the response from McKinsey.
Yes.
So I have personal knowledge
Yeah.
of the fact that the letter would have come to me
Yes.
because it's addressed to me.
Yes.
As I then said, if you have regard for the response in terms of each of the issues that was raised, in principle, they did not reject any of it. So from that perspective, Mr. Chair, I am saying that they had acceded to each of our requests. First point. Second point, at some Steerco thereafter, we did raise the concern that in the responses that McKinsey had given us, notwithstanding the fact that I agree that they had in principle agreed to each of the issues, there may still be a need for us to understand how this thing will holistically fit into the, let's call it, master services or top engineers program. And that concern was raised at the stage. So that is what I have personally.
So you are saying to me, at a certain stage, after you had received their response, ESCOM was not satisfied that they had met all the requirements.
That is correct.
Okay.
Thank you, Chair. And on the one, Mr. Singh, on which you agree with me, was never met, Dr. Weiss, which is the BEE partner, Dr. Weiss, Chair, I'm going to just refer to paragraph 74 of ESCOM Bundle 14, bracket, page
Yeah.
700.
Yeah. Do we
He
need to
actu-
go there or not really?
I'll read it to you, Chair.
Okay, all right.
Yeah. Because he talks about,
Where is this?
okay, page 700 of Dr. Weiss's, paragraph 74. Maybe the
right.
chairperson can go there as well.
It's paragraph?
Paragraph 74.
There we go.
Essentially what he's saying is, the contract was ultimately terminated without McKinsey being able to appoint another supplier development partner. So you will see it's right towards the end of the paragraph. I'll read the proposal and discussions we had with ESCOM about this fund. They established a fund, anticipated that McKinsey and ESCOM would decide together on new partners on the allocation of the fees that had accrued. Given the short period of time
You said
between
page, what page, Mr. Selena?
700,
700.
Paragraphs.
Okay, continue.
paragraph 74, given the short period of time between McKinsey's proposal of the SDNL fund and the termination of the turnaround program by ESCOM's board in June 2016, we ultimately were not able to identify any new partners prior to the termination of the turnaround program. So that requirement was in fact never, ever fulfilled. You see that?
Mr. Chair, the issue of the letter spoke.
Is it a yes or no to my question?
No, in the context of the way that you are presenting it, Mr. Chair.
No, the way he's, not me. He's
Yeah,
the one.
well, the way that he's presenting,
Yes.
Mr. Chair. No, let's get this straight. You are putting to me that the condition was not fulfilled because of what he is saying.
Yes.
And I'm saying what he is saying doesn't equal what you are asking. So you are putting a proposition to me.
Okay. What's
Yes.
yours?
And I'm saying,
Give your response,
What's
yes.
your-
and I'm saying, the letter that we wrote on the 19th sought to understand certain issues relating to BEE.
Which
We
letter are
mentioned-
you talking about now?
Sorry?
Which letter are you talking
The
about?
19th, the
19th
February
February,
letter.
your letter.
Yes, my letter.
Yeah.
Sought to understand certain issues relating to BEE and how they were going to integrate and what benefits will come out of it for them. Okay?
I thought, I'm not sure that I understood it to seek a clarification. I thought that it put a requirement to say, this is what we as ESCOM want.
Yes, Mr. Chair. So
Yeah.
what I'm trying to get to is that it was not Trillion specific. It could have been any BEE part that we were engaging in terms of the February 19 letter. And therefore, when the decision was made by McKinsey to say there's going to be no Trillion, the discussions around the BEE partner still continued. Because it was not as if that condition specifically related to Trillion.
But I think what Mr. Selega is saying to you is, Dr. Weiss is saying in paragraph 74 at page 700 that by June 2016, they had not been able to identify any partner who could have taken the place of Trillium.
Yes, ma'am.
Therefore, Mr. Slega is saying that means that if one follows the requirement of your letter of 19 February, that one of those requirements, which you said in the letter had to be met before the agreement could be signed, had not been met as at June 2016. That's the point he's making. And he's inviting you to say whether you disagree.
Mr. Chair, I think you can't go from here to the proposition that you are making, because the agreement may have still been signed.
No. Remember, the proposition that he is putting to you as formulated by me is
Which he seems
your
to defer to.
letter, is your letter of 19 February
Yes.
said there can't be the signing of an agreement unless all these requirements are met.
That is correct.
And now we see that on Dr. Vai's version, as at June, one of those requirements had not been met according to him. Okay? Therefore, if your letter was to be complied with, ESCOM could not have signed unless they were to act in breach of your letter.
No, I agree, Mr. Chair. And
You agree with that?
Mr. Chair,
Yeah.
it is, again, let me come back to this point and say, it is common cause that the letter was signed, because there's a physical signature. of
The
Mr.
agreement.
Yeah, I mean, the SLA. Sorry,
Yeah.
the SLA
Yeah.
was signed because there's a physical signature that
Yeah.
appears there,
Yeah.
okay, of both Dr. Weiss
Yeah.
and Mr. Mamalani.
Yes.
So, whether the conditions relating to my letter were either fulfilled or not is immaterial, because the contract was actually signed. The question is, when was it signed? Was it signed in October, or was it signed sometime in the first 6 months?
Well, the signing of whether the agreement was signed in breach of the requirements as set out in your letter probably would not be immaterial. But for present purposes, let's park that, okay? Isn't the position that if the requirements in your letter had not been met as at June, then based on your letter and not on something else, and maybe we can look at whether other factors might override this, but based on your letter, one would expect that no agreement had been signed by ESCOM because your letter had been clear that those requirements must be met. But that's separate from saying, are there other factors or events that happen which might have overridden your requirements in your letter? You understand that? In terms of simply looking at your letter, one would expect ESCOM not to have signed by June if one of those requirements had not been met. But it may well be that certain developments had occurred which might have persuaded Mr. Mabelane to sign, even if that requirement had not been.
Agreed, Mr.
You agree? Yeah. Mr. Selaga?
Thank you, Chair. And just to clarify this, Mr. Singh, that one requirement says the development of a BEE partner, bracket, regiment, group, close bracket, as regards the vision. So it appears to have been very specific. It may not have been to Trillium, but it was definitely to regiments. specific to regiments.
Where are you reading from, sir?
Your letter of 19 February,
Oh, this is.
number 4. Number 4.
Mr. Singh, we are all going to remember your letter of 19 February.
It seems so.
For a
Mr.
long
Chair.
time.
It seems so, Mr. Chair.
As well as-
It's becoming an infamous letter
As well as Dr. Vice's letter of 28 June.
of 28 June, yes. So the question is?
Now I'm saying, you were saying earlier, your requests were not specific to Trillion, the BEE partner request, but it is in fact specific to an entity, Regiments Group.
As in this, as that was applicable at this point in time.
That was?
Sorry, sir, as it's relating to this point in time, because it says, well, even
Okay.
if you look at it, I mean, at the end of the day, we're also recognizing Trillion at the end of the day in the opening paragraph. So it could also refer to Trillion. But my raising of these issues, Mr. Chair, in this letter, or what my intention was behind raising these issues, was to understand how was, or what was the actual plan to give effect to the intention that an SD partner, partnering McKinsey, would result in a, let's call it, an empowered consultancy firm. Right? And the reasons these issues are raised here come from the issues that Ms. Goodson has raised in the past relating to how McKinsey had treated, either you want to call it Trillion, well, Goodson was Trillion. So relating to the complaints that Ms. Goodson had raised vis-a-vis McKinsey and the way that McKinsey had been engaging with Trillion as their subcontract or potential subcontract. So that is the intention behind raising it. The issue was to get a very clear and concise answer in terms of how our objective relating to SD would actually realize at the end.
Yeah. No, all I wanted to place on record, because you were saying your requests were not specific to a particular BEE partner.
Yeah.
I'm saying, but your letter was. That's all I wanted to place on record.
Yes, and I'm giving you a response as to why it was specific, because it was specific to the company at that point in time. But had it changed over the life of the MSA, the point would still be, I want to know, as ESCOM, how are you going to develop these people, whoever they may be. But at this point in time, it's either Regiments or Trillion, as the letter is alluding to.
That's fine. Chair, should we carry on until 6:30? Or less?
Well, we should have talked at 4 o'clock, actually. You know, we normally talk about 4 o'clock. I would like us to go as far as we can today, so that to the extent that we don't finish today, we should finish tomorrow.
Yes.
Obviously, I'm interested in hearing what you have to say, what Mr. Singh has to say, and what his counsel has to say. But particularly because of the time that we lost in the morning, I would like us to go as far as possible. You know, Mr. Singh has been coming here for quite a few times. I know he will still come back for Transnet, and he might still, even if we do cover a lot of his evidence tomorrow, there might still be a little bit that he comes back for. But we are in April, and the intention was to finish all oral evidence by end of March. So I'm trying to push as much as possible so that we can finish, because I don't want to go into May.
Yes.
I may, well, there is already one witness in regard to my request, a date or 2 for May, but I don't want to go into May with oral evidence. I want us to finalize. So, counsel for Mr. Singh. You have
Chairperson,
heard what I say.
I would be the last person to indicate to you that you shouldn't use as much time as you do. But I've already placed on record that over the weekend we were served with extra papers. Reading those papers, I understand from my client, took most of yesterday, because then I think on a Saturday evening we got a whole bundle of annexures. Based on that, the client then had to go and read other documents to place it in context. If you work throughout the weekend, and in fact, he started on Friday, I do not think it's fair to a witness, and Chairperson, you know it yourself from practicing, to keep a person that's tired in a box and keep on pushing. People lose their concentration. And was it dependent on me, I would have said, let's try and push through. But at this point, I would rather let us start tomorrow early. I think we've made up 2 hours of the hour and a half we lost this morning. I would much rather that we start tomorrow morning early and give my client an opportunity to, yeah.
Well, you see, even if we had started on time, my plan was that we were going to go into the evening. So there is that part. But if and when a witness says, I'm tired, I'm exhausted, I will stop. But I don't think Mr. Singh will say that if he is not really tired and exhausted. So I'm quite happy to say, if and when Mr. Singh says, look, I'm tired, I'm happy that we adjourn, that we will, because it would be unfair to continue.
Chairperson, may we take maybe 2 minutes of your time? If we can adjourn for 2 minutes, let us just confer with our client.
Yes. But it's important that we all do the best. I know that certainly there has been cooperation in terms of us working into the night to try and finish. But we have sat for about close to 2 hours since the last break. So maybe it's fine, let's take a break, and then we'll finalize the subject when we come back. Okay, let's take a 10-minute adjournment. Okay.
Chairperson, Mr. Seleka undertook to deal with two questions. He said he's going to be finished before past, and we conceded to that.
Well, I must decide. You said if it depended on you, we could go on for some time.
But the client is tied. He actually wanted.
What is your situation, Mr. Singh?
Mr. Singh, I would appreciate, sorry, Mr. Chair, I would appreciate
You see, he's really tired.
if we could adjourn early today.
Yes.
And tomorrow is probably, we could go on a bit later tomorrow.
Yeah. So how much else do you need to deal with regard to Mr. Singh, in terms of issues
Yes, Chair. I
other than the MSA?
Yeah, no, I thought we could finish the McKinsey matters when I was saying at 6:30,
Yeah.
inquiring with the chairperson at the time, exactly during that space of time,
Yeah,
which was about 35 minutes.
yeah,
That would have left us with the Tegeta matters,
Mm-hmm.
Tegeta transactions, which we have led evidence on them previously before the commission, and I envisage that we could run quite fast with on those matters in the morning tomorrow.
Okay, look, we have reserved for tomorrow to try and finish Mr. Singh's evidence. But last week I did postpone to tomorrow Ms. Norma Dikaba's evidence for the evening session. So we do have some time, but if indications are that we should finish with Mr. Singh's evidence by lunchtime, then there might be no need for us to try and go too far this evening, because then we'll finish early and maybe still have some hours and so on. So what is your assessment if we finish the two issues that you talked about to counsel for Mr. Singh? Well, on Tegeta, how much time do you think we would need more?
I think we will need the whole morning, Chair.
The whole morning?
Yeah.
Okay, all right. No, that's fine. We are at 6:15 now. We go on until 5:30, or you would like, provided Mr. Singh agrees and his counsel, to go up to 2:45 so that you finish those two issues, and then tomorrow we start on Tegeta, or what is the position?
Yeah, so tomorrow it will be, well, I shouldn't only mention Tegeta because the travel agent
Yeah,
issue should also be touched upon.
yeah,
But I think we can finish the McKinsey matters now.
Yeah.
I had anticipated 30 minutes.
yeah.
But I don't know whether it will be
Can we
less.
try that, counsel, for Mr. Singh? 30 minutes? Mr. Singh, would that be fine?
And let's give it a try.
Let's give it a try. If you feel that you have become too tired, let me know. There is no intention to force you to testify even when you are tired, because you are the only one on that hot seat.
No, Mr. Chair, 30 minutes would be
Is that fine, counsel? Okay, all right.
Thank you.
Okay. So let's continue. Maybe we might finish around about 7:15.
Yeah, we might finish earlier than that. Mr. Singh,
Okay.
ESCOM Bundle 14, Mr. Singh, page 769.
Sorry, Mr. Chair. I don't know if that light has moved or something has happened to it. but
Or
it's
is
like-
it interfering with
Yeah.
you?
Because it wasn't before. so I'm
Yeah,
not too sure.
okay. Can somebody adjust it or?
That's fine, Mr.
Will that be fine?
Yes, thank you.
Okay, all right.
Yeah. Back on that service level agreement,
What page
page-
reference was it?
page 769. This is going to go fairly fast, Mr. Singh.
Well, maybe I should take long to turn to the page.
769. No, are you in the right bundle?
I'm there, sir.
Yeah. Paragraph 22. The PFMA requirement. So the clause reads, the person you are there. Is the chairperson there as well?
Yes, 769, I'm there, yes.
Thank you, Chair.
What document is this?
Is the same service level agreement, Chair.
Oh, okay, all right.
Clause 22 of this agreement, PFMA, the parties acknowledge that the employer is obliged to comply with the provisions of the PFMA. In light thereof, the parties acknowledge that the employer will not be required to, bracket, and the employer warrants and represents to the contractor that it shall not take, close bracket, it shall not take any steps contemplated in this agreement, including the execution of this agreement, unless and until it has secured any approvals or consents that may be required in terms of the PFMA. Now, when Mr. Koko was here, Mr. Singh,
Sorry, who's that? Miss?
Mr. Koko,
Yes.
when he was here, he said this MSA or SLA should never have been concluded because ESCOM did not obtain the National Treasury approval to appoint McKinsey on a risk basis as opposed to a tariff basis. I suppose you don't disagree with him.
So the question is, Mr.
Question
Do
is,
you agree or disagree with Mr. Koko's evidence that this agreement should not have been signed because the approvals contemplated in clause 22, approvals in terms of the PFMA, were not obtained?
Mr. Chair, in terms of, I have not seen Mr. Koko's evidence in detail regarding this aspect. But from what I can recall, again, Mr. Chair, these issues were not within my personal knowledge at the time. As I've explained before, through my interactions at the parliamentary inquiry, I had to gather this information. So one of the annexures that we've submitted through the affidavit that we received this morning is actually an email from National Treasury that confirms that the practice note that was applicable at the time allowed for risk-based contracting. So that is what ESCOM had relied upon at the time to ensure that the basis on which this contract had been concluded was appropriate.
I'm not sure if I follow. What is your answer to the proposition that if the approvals required in terms of the PFMA were not obtained, the agreement should not have been signed?
Mr. Chair, if having regard to paragraph 22, as I understand it to normally apply, Mr. Chair, these approvals would reference either section 54, 2B, I think it is, of the PFMA, where you would require specific approvals in terms of capital projects. Else it would reference the materiality and significance framework that would either deal with capital projects, procurement contracts, and the like. I do not specifically recall that there was a requirement. Well, basically the PFMA says you must comply with all legislation. And to the extent that the prescripts of National Treasury form part of legislation, we would require to comply with it. And hence I am saying, if it is contemplated that the remuneration model of the agreement is contemplated in this section 22, then I am saying ESCOM relied on the email that it received from Mr. Chitifango of National Treasury. He was, I think at the time, the Chief Director in Governance and Monitoring in the Office of the Chief Procurement Officer, that indicated the required schedule was applicable at the time and enabled this type of agreement to be entered.
Without approvals.
From my reading of the email,
yeah.
it did not require, it did not say
Subject to approvals.
approval. It
Okay.
said the practice note is applicable, and therefore this type of contract can be entered in.
Okay.
It then went on to say, listen, you must make sure of certain things. But it didn't say, you know what, send me a formal approval request that I would then approve for you to do this.
Okay. Mr. Slega?
Thank you, Chair. Mr. Singh, what transpired in court is consistent with what Mr. Koko said, which is that in order to appoint McKinsey on a risk basis contract, that ESCOM required to have the approval of the National Treasury. He distinguished that appointment from what ESCOM did in regard to McKinsey in relation to the corporate plan. He said the corporate plan was specifically on a confinement, but on a fixed rate. Well, the amount was agreed, or the contract price was agreed. In this case, it was on a risk basis, that you are paid only if you achieve the outcome of the contract. He said to the chairperson, the conclusion of the contract without the National Treasury approval was wrong. It should not have been done. Yeah. And what exactly are you saying to what he's saying?
So, Mr. Chair, maybe we should just clarify, firstly. The issue when you say, Mr. Seleka, that the court relied on the same assertion that Mr. Koko is making.
No. I say what was said in the court papers where ESCOM sued McKinsey and Trillium.
This is Mr. Hadebe's affidavit.
Say again?
This is Mr. Hadebe's affidavit.
Yes.
Okay.
It carried the same theme, that there was no National Treasury approval. Mr. Koko came here and said the same thing. So I'm trying to understand, just in response to that, what are you saying?
So, firstly, let me respond to your issue around Mr. Hadebe's court paper. Mr. Chair, Mr. Hadebe does indicate that National Treasury approval was required, but not for the same reasons that Mr. Koko alludes to, or I'm understanding Mr. Koko to allude to. Mr. Hadebe, in his court papers, and maybe we can refer to it if it's in the reference bundle as it says, we can go there, but from my recollection, in the interest of time, references the email that I've just referenced. But basically, waters down the emphasis that is placed on that email by Eskom, in that it says it is arbitrary, right? And also it is received from Mr. Chitifango, and we do not know his position, and we do not know if he was empowered to issue the email. Now, Mr. Chair, a simple Google search of who Mr. Chitifango is would tell you, as I've just told you, that he was the Chief Director in Governance and Monitoring, in the office of the Chief Procurement Officer of National Treasury. So that is the weight of the position that he carried. Secondly, if you read the email as I just said, it is quite clear that he does not say you require an approval for this. He says you can actually do it. So the issue of the court papers is a separate matter vis-a-vis what Mr. Koko has allegedly asserted. And I'm not privy to the basis on which Mr. Koko has made this assumption, and maybe if you give us some time, I'll go and refer to it, and I can come back to you and refer to it. But I know Mr. Hadebe does allude to the fact that National Treasury approval is required. The basis on which they rely on the fact that National Treasury approval is required is the ambiguity between which schedule was applicable at the time. So from an Eskom perspective, Mr. Chair, Eskom did engage with the council in terms of understanding which remuneration model is acceptable given the applicable practice note. And there was some ambiguity in terms of the opinion that was obtained, but it eventually said, just ask Treasury, because Treasury is the authority. Okay? And there was then a second opinion that was obtained, if I'm not mistaken, it was actually obtained by McKinsey themselves, that effectively said, actually, the practice note is applicable, and therefore you do not need approval. Okay? But notwithstanding that, Eskom thought it prudent to actually engage with National Treasury, and they engaged with National Treasury in a form of a meeting, I think. And the outcome of that meeting was this email that then was received from Mr. Chitifango on the 4th of February, I think, 2016. So that is the basis on which Eskom relied on the fact that it had the necessary authority to enter into this space.
Thank you, Chair. Mr. Singh, the starting point in regard to the requirement for National Treasury is exactly the appointment on a risk basis in Mr. Hadebe's affidavit. That affidavit is in Eskom Bundle 14D. Eskom Bundle 14D. And I'll give you the page reference.
I don't think I have.
11, page 1194.
Sorry, Mr. Seleka, you are at?
Page, paragraph 79, from paragraph 79. Well, Chair, sorry, can we start so that it makes sense? Let's start on page 1193. And I will read from the last paragraph, 78.4.
Just for the record, state whose affidavit we are looking at and obviously the page.
Thank you. Sorry, Chair.
I'm saying for the record, state whose affidavit we are looking at
Yes.
and the page,
Sorry, Chair. Thank you.
and obviously in what proceedings.
Yes. This is an affidavit, Chairperson, of Mr. Pakamani Hadebe. It is a founding affidavit which was filed in the court case number 22877/2018, the applicant there being Eskom Holdings against 5 respondents, the first being McKinsey and Company, and the second being Trillion Management Consulting, the third Trillion Capital Partners, and then the National Director of Public Prosecution was also cited, as well as the fifth respondent, MMS Ngumalo N.O. The affidavit starts on page 1161 of Eskom Bundle D, and it runs all the way to page 1132, and is dated 29 March 2018.
Yeah, okay. You said we must go to 1193.
Yes, yes. Yes, Chairperson. Page 1193. There are a couple of issues, but I want to concentrate on this one of the National Treasury requirement. I'll start, Mr. Singh, rather at paragraph 78.3. It says, third, there was no cap or limit placed on what could be paid out under the Master Services Agreement. This is particularly concerning in light of the PFMA requirements mentioned above. 78.4. Finally, there was also apparent awareness that this agreement would trigger the duty to report this transaction to the Minister in terms of Eskom's significance and materiality framework and the relevant PFMA provisions. The minutes record that. A number of questions were raised with regard to the PFMA implications for this transaction. In response, the team advised that they were aware that the transaction falls within the materiality framework and that discussions around PFMA were in progress. However, the Minister was never notified of this proposed Master Services Agreement, either before or after its conclusion. Paragraph 79. This was a further and a far more significant difficulty with this decision. There was a further and far more significant difficulty with this decision to approve the conclusion of the Master Services Agreement. Eskom had not obtained National Treasury's approval for the intended deviation from the National Treasury Instruction 01 of 2013/14 on cost containment measures. The National Treasury Instruction, in brackets. Then it reads 79.1. At all relevant times, the National Treasury Instruction was in operation and it had been specifically incorporated into Eskom's own internal policies through the Eskom position paper PPO3 signed by Mr. Koko in August 2015. As explained above, the National Treasury Instruction and the Eskom position paper PPO3 require that external consultants may only be appointed as at prescribed rates, based on a clear business case and following a gap analysis. Any deviations required National Treasury's approval under Section 79 of the PFMA. From early on in the negotiation process with McKinsey, ESCOM officials raised the concern that the National Treasury instruction did not permit risk-based remuneration. Then we carry on. The next page, paragraph 80.1. On 29 June 2015, Ms. Valetti, the then acting CFO, specifically recorded that the National Treasury instruction must be complied with in relation to consultant rates. And if an alternative methodology such as incentive-based is used, we need to verify that it is permissible. This letter appears at item 25 of the record bundle. And then on 2 September 2015, Mr. Singh, you would be there by that time, Mr. Aziz Laher, ESCOM Group Compliance Manager and PFMA Corporate Specialist, addressed an email to a number of ESCOM officials, including, amongst others, Mr. Martin Buys, Mr. Prish Govender, Mr. Mayabana, Ms. Mayabana, Mr. Charles Kalima, and various parties from legal and compliance and professional services. In that email, Mr. Laher specifically recommended that ESCOM would need to apply to the National Treasury for approval of the deviation from the National Treasury instruction. And then the email is in the record bundle. Mr. Laher raised this issue yet again in an email dated 14 September 2015. And on or about 27 October 2015, Mr. Laher was called to a meeting in Mr. Koko's office. The meeting was attended by Mr. Edwin Mabelane, ESCOM's Chief Procurement Officer of ESCOM, Mr. Prish Govender, ESCOM's then Project Director of Group Capital, and two representatives from McKinsey, Mr. Vikas Saga and Dr. Alex Weiss. At this meeting, Mr. Laher was told to explain why he was holding up the conclusion of the Master Services Agreement, with his view that National Treasury approval was required. Mr. Laher explained the restrictions imposed by the National Treasury instruction and advised that the only way forward was to apply for approval. Mr. Koko stated his intention to obtain an external legal opinion on the matter. McKinsey also stated that they would provide their own view about whether the remuneration model was in line with National Treasury instructions. If I may stop there, Mr. Singh, what we have read so far specifically deals with the National Treasury requirement if you were to appoint McKinsey on a risk base or risk basis. So it's very clear and consistent with what Mr. Koko said before the Commission. Yeah. Your comment?
Mr. Chair, as I've mentioned, none of these issues that Mr. Seleka raises was within my personal purview at the time.
Okay.
In terms of my response, I've given my response in terms of the reliance that ESCOM had placed on the two opinions, as well as the email that was received from National Treasury.
Mm. And
So I take that to mean that you are saying, look, I don't have personal knowledge of these matters, so I'm not in a position to agree with them or disagree, but all I am saying is that my understanding is that at a certain time, a note was obtained, or email was obtained from National Treasury, which I understood not to say we needed approvals in terms of the PFMA before the agreement was signed. That's what you are saying, is that correct?
That is correct.
Okay.
thank you, Chair. The allegations go further with the opinions that are obtained by ESCOM, which says approval is required, and then by McKinsey, which says, well, we are not sure, but let's take a chance. Let's proceed without an approval. But of course, McKinsey, Mr. Singh alluded earlier, that they have come on record saying they were misled by ESCOM. ESCOM said to them they had obtained the approval when in fact they had not obtained. Is that correct, Mr. Singh? That's what McKinsey is saying.
Well, Mr. Chair, if we're going down this road, we ain't going to finish before 8 o'clock.
Is that because you are going to say no? That's not your understanding.
Well, it's not my understanding, Mr. Chair.
Of McKinsey's version.
Well, Mr. Chair, this
No.
is the reason. If
When-
we're going...
Let me say this. Whether or not they are right is another matter. But I was saying, you understand what I'm saying?
No.
Because you can come back and explain it tomorrow. Whether or not they are right that they were misled is another matter. What I'm saying is, you alluded to that version that earlier, that they say they were misled into thinking that ESCOM had obtained the National Treasury approval. That's all I'm saying now.
So you wanted him to confirm whether your understanding of what he said was correct,
Yes.
namely that
Yes.
McKinsey said they were misled.
Yeah.
Whether that they were right in saying so or not, you are not going
No,
there
I'm not
now.
going there. You can
Okay.
deal with it tomorrow, Mr. Singh.
Okay.
But you know that version of theirs.
Yes, I do, Mr.
Yeah,
Chair.
that-
And for the record, I don't agree with it.
Yeah.
Yes,
Okay.
that's all.
Okay.
We're dealing with it tomorrow. Because then on page 1199, Chairperson, paragraph 87,
1199.
1199, paragraph 87, then there's the affidavit reads, despite these concerns over the lawfulness of the agreement, Mr. Mabelane proceeded to issue an acceptance letter to Dr. Wise on 17 December 2015. So, I mean, you know in this affidavit, because of what you've said, you've read it, where there's an exchange with an official from National Treasury. And a concern is raised, as Mr. Singh has said, Chair, that this is just an email, whether it's a...
Well, I don't know. Well, it's here somewhere.
Yeah, no, it is somewhere there. We can go into it tomorrow. But first and foremost is the issue of the approval. Does it mean you knew, you said it was not within your purview. So then Mr. Koko had knowledge, because he was in that meeting. The policy was signed by him, dated August 2015. I suppose, well, let me ask you this, whether you can dispute what he's saying about the requirement of the approval.
Well, Mr. Chair, as I said, I'm not too sure what Mr. Koko said in evidence. But if I just had to add reference to paragraph 81.4, Mr. Koko stated his intention to obtain an external legal opinion on the matter. McKinsey also stated they would provide their own view about whether the remuneration manual was in line with National Treasury instructions. Now, if it is alleged, as Mr. Saleka is saying, that Mr. Koko signed the policy document, knowing that approval was required, in my view, then an instruction would have followed from Mr. Koko from this meeting, do the necessary that is required to comply with the policy. Yet his response here is his intention to obtain an external legal opinion on the matter, which then led to the opinions that ESCOM had received. So, in my view, this indicates that, notwithstanding the fact that he signed the policy, there was some doubt in Mr. Koko's mind as to whether it was applicable or not. Hence, he sought legal opinion.
Yeah, but I think
Yeah.
he has cut a long story short, Mr. Singh. When he came here, he was very unequivocal. He was very clear to the chairperson. The chair, you will recall, I even said, that helps, that spares 3 hours of going into the MSA. So if you go to his transcript, the 29th of March 2021, that's when he testified.
Well, Mr. Chair, as I said, at the end of the day, I can only go on what is here.
Yeah.
And based on what is here,
Yeah.
it would seem that at that point in time, There was some ambiguity in his mind. Hence, he's requesting a legal opinion. Because if he was as emphatic as what Mr. Seleka says when he sat in this chair, then the logical thing to have done was to say, Mabalani, get the approval. Operation, get the approval. Because Mr. Lehe is right.
Yeah, no, that's
Sorry.
fine.
Thank you, Chair.
You are not done yet? Okay.
Yeah, that was the first point, Chair.
Oh, that was the first point. Well, we will respect the arrangement. Mr. Singh, can he go into his second point?
The second.
Okay, all right, okay.
The second point, Mr. Singh, is on page 811.416
Of this bundle or the other?
of that. No, sorry. Sorry, Chair. ESCOM bundle 14.
Mr. Chair, I think Mr. Seleka requires some time.
You need to take some rest.
I think Mr. Seleka requires some rest.
You know, he is the only one who has been standing the whole day,
That is true, Mr. Chair. that is
but
true.
I envisage, Chair, I think I'm going to propose we adjourn. I envisage there's going to be follow-up questions from this.
yeah, okay.
Yeah,
Okay, no, then that's fine, let's adjourn then.
yeah.
I think that it would be good if Mr. Singh could get a chance to have a look at Mr. Koko's evidence that has been referred to.
Yes.
Because in answering, he has emphasized that he has not seen that evidence.
Okay.
So that tomorrow, if he has picked up anything that makes him qualify his evidence or add to it, he can do so. So I guess that you would be able to indicate where he would find it,
Yes,
the relevant evidence.
it's already on the website.
Yeah.
29 March 2021.
You gave me a page reference. Okay, it's fine. No, I'll find it.
Okay, thank you very much to everybody for your cooperation. Let's adjourn now. And tomorrow, we could start earlier than 10, but there is no point in starting earlier than 10 if we are going to finish on time anyway. So should we make it 10 o'clock?
I think so. 10 o'clock sharp.
Okay, all right. We'll adjourn then until tomorrow at
Thank you,
10.
Chair.
We adjourn.